You're live.
Great. Welcome. This is February the 16th, 2021. Welcome to the House Judiciary Committee for our day of hearings today. All the bills today will be working under the 3 and 2 rule, meaning 3 minutes for the sponsor and 2 minutes for the witnesses. Members should be advised that you should put yourselves on mute until you're recognized, and then we'll hear from you and we'll hear from your witnesses. Our first bill today only has one witness and is himself, Delegate Hornberger, and that's for House Bill 696. And if I could find my timer, we would be really good shape. There we go. There's the timer. Okay, so we'll be good. And you'll have 3 minutes to testify on your bill. Okay, Delegate Hornberger, please go ahead.
Thank you, Mr. Chairman, and I really appreciate you letting me go first before my other colleagues. For the record, Delegate Kevin Hornberger here on HB 696, Public Safety, Consumer, and Display Fireworks. This is a pretty straightforward bill, and this is actually our second year introducing it. Last year, believe it or not, was Economic Matters, and then the wisdom of bill drafting got assigned over here to Judiciary, which is exciting. And what this bill seeks to do is, as many of you know, I'm in Cecil. We're one of those counties that borders Delaware and Pennsylvania. And every year around the holidays, there are a plethora of fireworks stores immediately across the border in Pennsylvania. And this goes for all of those border counties on the north end of Maryland. And what's happening is that folks are crossing over the border, and the way that things are set up in Pennsylvania, all you have to do is be someone who's out of state, show your ID. You can purchase the fireworks that we're looking to bring into Maryland to make legal. And then you travel back across the state line and folks are lighting them off. And you might say, oh, well, that's illegal. You know, we don't want folks doing that. It's not safe. Well, firework accidents have actually been on the decline for the last 10 years. And last year when we introduced this bill, the state fire marshal's office was obviously very interested in it. And they said, look, we don't support the way the bill's written, but we would like to offer an amendment. This amendment came late in last year's session with all that was going on. We have incorporated that amendment, and basically that tightens up the permitting process. So if you want to sell these fireworks, we're all familiar, 4th of July, the side of the road, the tent at the gas station, you can go and buy your sprinklers and such. This would include another class of fireworks that you can currently buy right across the border, and it would put in a permitting scheme so that the state fire marshal was aware of all of those places where these fireworks are being sold, and then would also set up some parameters about where you can set these fireworks off. For example, if you take a look at the fiscal note, 300 yards from a building, of course, outdoors, all of these sort of safety things that will continue to make 4th of July and all that an enjoyable holiday. And then in closing, I would also add that Elkton, the area in Cecil County, is one of the longest manufacturing of said fireworks that we have in the state. So much, in fact, that some of the plants were the first places that they developed things like rockets and stuff for the military. Thiokol is also located there. So a little bit of a history lesson. But they currently can't sell the products that they manufacture in Maryland. They have to be transported out of state and then sold only to be carried back in by consumers. So this would be a pro-economic development bill. It has no fiscal impact. And like I said, the state fire marshal has been involved in discussions. So with that, I'd like the committee to move favorable and happy to take any questions. Thank you, Mr. Chair.
Are there any questions for Delegate Hornberger? Let me pull that up. And there are. Delegate Griffith, then Delegate Juanita Fisher. Delegate Griffith, please.
Thank you, Mr. Chair, and thank you, Delegate, for bringing this bill forward. So I'm going to ask a two-part question. One, could you talk about the amount of, with so many places not having their Independence Day fireworks this year, could you talk about the volume of people throughout Maryland that were setting off fireworks, the likelihood they were purchased immediately across the line? And if they were purchased in the state of Maryland, what that could mean in tax revenues to pay for a variety of things we're trying to push forward as a body.
Sure, that's a great question. And I actually had some notes on that here that I wanted to bring up on my phone. Fireworks sales are measured in pounds, believe it or not. So the number of pounds of fireworks that's been sold in Maryland has continued to go up. And these are just for your traditional sparklers, things you can buy currently at the roadside stand. However, those cross-border sales have exploded. And that's because they have more variety there in Pennsylvania that they can sell. So as a result, we're missing out on a tremendous amount of economic opportunity. And as you alluded to, many of those very large, spectacular fireworks displays that we have, I think Hartford County, the Bel Air area was one of the only places that did it this year. I don't know who helped with that, but they got it across the finish line. But with all of those shutting down, this gives a little bit more autonomy and independence to citizens to be able to light off, the ground-based sparklers, et cetera, that you could buy across the border. So great question. Thank you.
Thank you.
Delegate Juanita Fisher.
Thank you, Mr. Chair. Good afternoon. Hi, Delegate.
Afternoon.
My question really has to deal with, particularly in my local neighborhood, like where my house is. I literally could send you video of like the crazy fireworks going on that people are doing in their own homes, which is, illegal without a permit. And
Yes.
how does this bill help local counties in the enforcement arm? So I think a lot of issues around, the personal use of fireworks is on those holidays like July 4th, you're talking about, and others, our police force is already busy with other things.
Yep.
So even though that's illegal activity going on, they may not necessarily be going in to do that. And then you have to deal with the fact that it's on someone's personal property. So they don't, and entering the home and all of those things if they don't witness it. And it's very hard to enforce. And so I wonder if your bill has any support to local counties when it comes to the enforcement arm of this. Because it's already such I see Delegate Williams shaking her head. It's a very systematic problem in Prince George's County. It's
Sure.
out of control. And that's kind of my fear and concern, and how this bill will help our local counties in enforcing the law.
Yes, great question. And I have also some anecdotal experience too from my county. Our sheriff's department is the authority having jurisdiction. And during, 4th of July, that day before, that day after, things get crazy and there's folks lighting them off, running in their house, et cetera. This bill actually seeks to tighten up what the definition of a firework is. And if you take a look at the fiscal note, it'll go into great depth. One of the problems with buying something out of state and then transporting it back in is that once you cross that border, there's no record of purchase. So by having those facilities here and having them licensed, you have to show your ID to purchase them. There's now a log of you purchasing that firework. So let's say that someone bought it legally, but wanted to light it illegally. This would provide a way for Maryland State Police, Sheriff's Department, et cetera, one, to track that purchase and see that, in fact, this was the person that bought them. They bought them at this store on this date. And then because of the definitions being tightened up, they would be able to say, yes, that firework that you lit was illegal where you lit it. And it would make it be able to be a chargeable offense at that point. So are we going to be able to stop folks from breaking the law? No. But one of the reasons they're doing it is because it's so easy to get away with. And I think that the passage of this bill would actually assist law enforcement to try to clamp down on that, because they'd be able to trace where it came from and who bought it and get that responsible party.
Are there further questions for Delegate Hornberger? All right, seeing none, we thank you very much.
Yep, thank you.
Thank you. That concludes the testimony for House Bill 696. Now, someone actually here with us today. Huh. Were the courts open yesterday?
In Pennsylvania.
Oh. House Bill 678. Well, good. That's the requisite amount of hard time I'm giving Delegate Buckle.
Thank you.
For the record, the chair will not be answering questions as he had to yesterday for Delegate Buckle's other bill.
I heard you did an excellent job.
Yeah, well, it's another service I provide, apparently. House Bill 678. There is one witness. It is Delegate Buckle. And so we'll hear from him for 3 minutes.
Thank you, Mr. Chair. And I do apologize and appreciate the committee's indulgence with respect to yesterday. I was unfortunately scheduled to a litigation matter in Pennsylvania via Zoom, of course, that conflicted. HB 678 is a bill that I believe the committee has seen once before. It's really very straightforward, and I want to preface it simply by saying this. On the 7 years now that I've served in the House of Delegates, I have been educated and persuaded in some circumstances by members of this committee and by members of the majority party who have expressed concerns about potential decriminalization or liberalization or a trend towards rehabilitation for certain nonviolent crimes in Maryland. That has been a theme that I have heard quite frequently in the 7 years that I've served in the Maryland legislature, that perhaps our penalties are too harsh and we are too overly focused on nonviolent criminals and we could come up with a better system. This bill is perhaps the other side of the pendulum from that response. I have taken those concerns into my heart and into my logic of how I approach these criminal justice issues, and I hope that members of the committee take the concerns and the problems with violent criminals and them returning to the streets and returning to a pattern of violence, unfortunately, because that's what HB 678 is about. In very straightforward terms, under existing law, if you are convicted of a crime of violence, you are not eligible for parole until you have served 50% of your sentence. The Department of Public Safety and Corrections indicates that in general, the average rough time that individuals are paroled for a crime of violence is approximately 70%. What this bill would do is it would say that you're not eligible for parole for a crime of violence until you have served 90% of your sentence. We all know and understand, I think probably the chair of the committee is one of the few who've had to make these decisions in real life as to how to offer plea agreements, as to sentencing agreements, and what is fair and correct and reflects all of the principles of justice that go into sentencing decisions. We all understand that sentences are not necessarily automatic in Maryland. There is a degree of discretion, although we have sentencing guidelines. And some of the factors of what is an appropriate sentence for a crime of violence already are put into the mix before the sentence is issued. And I think that once that sentence is issued, once that individual has pled guilty or been convicted by a jury of their peers, and once the state's attorney's office, and once the defense, and once a judge appointed through our process or elected by our process has had the opportunity to weigh in on sentencing, those narrow classification of violent criminals should be subjected to a higher percentage of their sentence before they become eligible for parole. Again, it's very important to know who we're talking about: murderers, attempted murderers, armed robbery, shooters, rape, serious criminal offenses, first-degree assault with deadly weapon. Those types of individuals that are a narrow subset of our communities and a narrow subset of our state, but wreak havoc upon our communities. And they are the violent criminals that we should be focused on, and we should be focused on trying to keep in prison and not on our streets. And that's all the bill really does.
All right. Are there questions for the sponsor of the bill? All right.
Yesterday.
Now, today's bill, Delegate McComas.
Yes. Delegate Buckle, do you know, if you know, usually how many times has there been a parole hearing for a violent offender, kind of an average, where the victims have, get notified and have to appear? Because I guess, how does that affect the victims?
I don't have any statistics on that directly. I can tell you that in my district, my legislative district is the North Branch Correctional Institution and the Western Correctional Institution, which are two essentially maximum security prisons where many of the state's violent offenders and long-term sentenced individuals are incarcerated. And I can tell you from some personal experience, at least with the parole commissioners who travel to our region, at least they did prior to the pandemic, that, it's fairly frequent, but I can't tell you exactly how many times an individual who may be serving a 20-year sentence for a serious crime, perhaps for attempted murder, for example, or rape. I don't know how many times from the 10-year point eligible up until such time as they are released eventually. I don't know how often that would be, but I'm sure, common sense suggests that it's a difficult and traumatic experience, perhaps for the victims' families.
Could I just have a follow-up, Mr. Chair? Do you know, since you live in an environment where there's a lot of correctional facilities and correctional officers, does Maryland have I know Patuxent deals with sex offenders and they have programs, but do we have a specialized group that deals with violent offenders that could maybe help them when they are released? I mean, do we have a specialized type of program?
I don't know if there are any specialized programs for that. I'm sure that those individuals who are eligible for release are afforded the rehabilitation opportunities. And that's our goal for everyone, is not to become a recidivist and to have changed behaviors. I'm sure they're eligible for all the programs that, for example, North Branch and WCI have, which are extensive. But I don't know if there's anything particularly directed towards crimes of violence convicted individuals.
Thank you.
Delegate Grammer.
Thank you, Mr. Chair. I just thanks for the bill, Delegate Buckle. I just have one question for you. The people who commit violent crimes and are convicted of violent crimes, can you speak to the rate of recidivism? I want to try and get a feel for how much this bill, how far it would go in preventing repeat offenders.
I don't have specific information with respect to breaking out the rate of recidivism for violent criminals as opposed to the general rates of recidivism. Our recidivism rates in Maryland, I think, have come down in the last few years, but they're still relatively high, unfortunately. And I don't have any particular information from DPSC or their analysis as to separating that from property crimes, narcotics crimes, as opposed to crimes of violence. What we want to do with this specifically is, if you've already demonstrated that you're willing to shoot at someone, you've murdered someone, you've seriously injured someone, you've raped, sexual assault of that nature, we believe that your chances of causing harm, if you choose to become a recidivist once you're, or commit crime when you're out, that risk is so much higher than if you're simply in prison for you were a minor to moderate drug dealer or you had a minor to moderate theft type charge.
So focusing on the real violent offenders.
That's right. I think that's something that hopefully we can unite in throughout Maryland, is let's focus on those individuals who are doing harm through violence to all of our communities, and let's go after those individuals rather than a broad brush approach to all types of criminal classifications.
All right, thank you.
Are there further questions for the delegate? Seeing none. Thank you all very much. Thank you, Delegate, very much for testimony today.
Thank you, Mr. Chair, members of the committee.
Thank you very much. That concludes the testimony for House Bill 678. Now we're going to go to House Bill 666 with Delegate Barron, who drew the unlucky straw apparently this year with House Bill 666. And we're going to hear from him for 3 minutes. And we're also going to hear from Robert White from the DC Council. So we'll hear from them, and then we'll hear from person in opposition. Okay, Delegate Barron, for 3 minutes, please.
Thank you, Mr. Chair, Madam Vice Chair, esteemed colleagues, members of the Judiciary Committee. It's my pleasure to be before you this afternoon to introduce to you House Bill, unfortunately, 666. My friend, Robert White, who happens to be an at-large member of the Council for the District of Columbia, successfully championed legislation in DC that adds greater accountability, transparency, and oversight to the Washington Metropolitan Area Transit Authority and its police department. The bill before you is the next step in making his work a reality. Now, because Metro is a compact, the same legislation has to be approved in Maryland, Virginia, and approved by the federal government. The bill does two things. First, it establishes an 8-member civilian oversight review board over the police department with 2 members each from each jurisdiction. Secondly, it prohibits the use of quotas, arrest quotas, citation quotas, warning quotas, to evaluate or incentivize or discipline police officers. The Civilian Review Board would have power to investigate, adjudicate, mediate, and dismiss complaints against officers. And depending on the complaint, it could forward it to authorities for the possibility of prosecution. there's been a number of high-profile, alleged police misconduct incidents by Metro Police. Also, a number of high-profile incidents of quota contests by members of the police department. It's gotten so bad that the union has sent a letter to management about it and about discrimination against Black and brown police officers. This bill will go a long way towards improving community and police relations, particularly as it relates to the Metro Police Department. It would ensure accountability and oversight. And I urge your favorable report. Happy to answer any questions. I'll probably try to defer mostly to my friend, Councilmember White.
Okay, we'll go to Councilmember White for 2 minutes now.
Thank you, Chairperson Clippinger, and good afternoon to members of the committee. I'm Robert White, Council Member at Large for the District of Columbia, and I'm honored to testify before you today on House Bill 666. The Washington Metropolitan Area Transit Authority, or WMATA, compact is an agreement between the District of Columbia, Maryland, Virginia, and Congress that created the second largest public transportation system in the nation. The bill before you today would amend this interstate compact to create a civilian police complaint board comprised of residents from the District, Maryland, and Virginia, tasked with oversight over MTPD, the Metropolitan Transit Police Department, the multi-jurisdictional law enforcement agency that polices Metro bus and Metro rail trains and stations. I had the privilege of chairing the committee with oversight over WMATA in the district in 2019 and 2020, during which time several incidents of excessive police brutality by MTPD occurred. That is why I introduced a companion bill for the bill before you today in the District of Columbia legislature. This bill effectuates an amendment to the compact that all three jurisdictions must agree to. The District of Columbia approved its amendment to the compact on December 15th of 2020, and I encourage you to do the same. MTPD plays a vital role in ensuring safe passage by residents in all of our jurisdictions. However, multiple incidents occurring over the past several years have highlighted how problematic policing practices on Metro can often make riders, especially people of color, including children, less safe while riding Metro. Meaningful accountability to any single oversight body is absent for MTPD, with that responsibility spread across three jurisdictions in Congress. My committee held a public oversight hearing with MTPD in November 2019, in which several incidents were discussed where MTPD officers used excessive force against riders, including one incident from the summer of 2019 when a teenage African-American boy was pinned to a Metro rail platform by an MTPD officer, and a bystander who attempted to de-escalate the incident was tasered so excessively that he suffered severe and permanent injury. There was another incident involving a 21-year-old woman on Metro bus having her teeth broken and suffering a fractured knee in front of her young kids for suspected fare evasion. In response to these incidents, we asked WMATA to publicly post MTPD data, including stop, search, arrest, and use of force reports, something that DC Metropolitan Police Department and many other police departments do already. My committee heard from current and retired MTPD officers about the concerning culture within the department, including racist and sexist attitudes and employee disciplinary and promotion practices.
Council.
One officer anonymously shared evidence of a contest advertised in MTPD offices rewarding officers for engaging in enforcement actions with greater points for more severe actions like arresting riders. While that practice has stopped, MTPD continues to evaluate officers by quotas on aggressive policing practices. This bill ensures that this does not continue. Mr. Chairman, I think you're letting me know my time has expired.
Yes, gently.
Thank you.
All right. Thank you very much. I am certain people will ask you questions, and I know that because I can go to them now. Delegate Nicole Williams, please.
Yes, thank you, Mr. Chair. Just really quickly, I saw in the bill, if if after the complaint review process has taken its course, if it's seen that there was an actual violations, it just simply says for the authorities to prosecute. And I guess my question is, how is that specified? Is it going to be the local authorities in the jurisdiction where the event occurred? Because you are talking about something that spans multiple jurisdictions. And so I guess my question is, how is that determined?
This would essentially be determined by the WMATA board. One of the things we were careful about in the compact is to not go into too much specificity, but to allow some room for the jurisdictions through our appointed members to the WMATA board to determine the best courses of action. So that is something that is not delineated in the bill deliberately.
Okay, thank you.
Thank you.
Delegate Grammer, your hand is electronically raised. Do you have a question?
Yes, sir.
Oh, okay, Delegate Grammer.
Thank you, Mr. Chair. Question for Delegate Barron. Good to see you. Thanks for the bill. So a few years ago, the state actually banned the use of quotas from jurisdictional law enforcement. Just to be clear, it looks like there are smaller law enforcement groups like this one that the use of quotas was still both permitted and in use.
Right. I believe that's the case. I mean, what we did in Maryland wouldn't apply to this entity, to Metro, because it's its own, it's governed by a compact. And so whatever changes to the compact would have to be done by each jurisdiction. So, those changes wouldn't have applied to the Metro Police Department.
Okay, appreciate it. Thank you.
Are there further questions for the panel? Okay, seeing none, we thank you both very much. And thank you very much, Councilman, for being here today.
Thank you, Chair.
Thank you.
We're going to go now to the single person in opposition, Colin Doherty. He's on right there. And we will, Mr. Doherty, we'll give you 2 minutes, okay?
Thank you, Mr. Chairman. I want to open by thanking the chair, vice chair, committee members for their time. My name is Colin Doherty. I'm a detective with the Metro Transit Police Department. Here today as chairman of our union, DC Lodge 1 of the FOP, and on behalf of Maryland State Lodge of the FOP. Here to speak in opposition to House Bill 666. I fully understand that it's not expedient to oppose legislation in favor of more police oversight. And I want to assure you that our union members do not oppose greater police oversight in general. Indeed, shortly after George Floyd was murdered last year, this union recognized the need for reform locally and nationally. We put that recognition into fast action by submitting a mission statement of Paul Wiedefeld, our general manager, imploring him to partner with us and taking immediate steps towards reforming our agency by making ourselves more accountable and improving our relationships with the communities we serve. Specifically, we demanded that the department stop evaluating officers using quantitative metrics and other standards that serve primarily to promote unnecessary stops and arrests. We demanded that MTPD leadership embrace stronger ethical standards of policing and begin a peer support program. Since then, management and the union have actively engaged in writing general orders and implementing positive changes as quickly as possible. Additionally, we demanded that MTPD leadership foster stronger bonds of diversity within the department and make immediate efforts to recruit, retain, and promote officers of color across the board. We demanded that efforts be made to do away with our stop and frisk culture that, however well-intentioned in the name of crime reduction, serve primarily to anger those members of the community whose lives suffer disparate interference as a result of. And finally, we demanded that the department find and implement a nationally recognized de-escalation training program that all officers are trained on and the community is invited to participate in. I'm happy to report that the department at WMATA immediately partnered together, formed 5 committees in pursuit of these points, each of which are actively engaged in the various aforementioned reform measures. As you can see, we're already actively engaged in halting the use of numbers to evaluate police, and we find ourselves wholly in agreement with the originators of this bill concerning this principle and thank them. This brings me to my next point, concerning our opposition to the proposed Metro Transit Police Complaints Board. I want to draw everyone's attention to the recently constituted MTPD Investigations Review Panel that WMATA took the initiative to form. This panel was formed this summer. They barely had an opportunity to come together and begin to function. Yet we find ourselves here with yet another board of oversight proposed, ready to stand in competition to that board. Should the MTPD Complaints Board be constituted by this legislature, the MTPD would find itself the only police agency in the state to have such a board overseeing it. While our officers are willing to be the vanguard of modern reform policing, I think that oversight of this agency should be in line with oversight provided for other police agencies within this jurisdiction. I'm confident that our officers face the consequences of their actions when those actions are deemed to have been contrary to the law and ethical standards. I can't sit here and tell you that I've never opposed the imposition of discipline on our officers, but I can tell you that this unit has rarely disagreed that discipline was appropriate in instances where officers did not act within the standards that we deem appropriate. As a community member, I want the same highly trained and professional cops work in our neighborhoods and streets that you want. I know that my officers want the same. On behalf of our union, I urge you to return an unfavorable report in this bill. I do want to say that this is not a zero-sum legislative battle, and I ask you to continue working with my organization, my police department, and the community on those measures. We're already acting in support.
Thank you very much.
And I want to thank the committee for their time. Yes, sir.
Thank you very much. Are there questions for the witness? We're going to go to Delegate Grammer.
Thank you, Mr. Chair. Mr. Doherty, brief question. Do you object to the board? Do you object to the board? Do you object to the quotas, or do you object to both?
We object to the board, sir. The legislation in favor of eliminating the use of quotas or quantitative metrics, as we commonly refer to them, semantics. I am not in any way, shape, or form opposed to that. I can tell you that the Metro Transit Police and the union have worked together to draft a new general order on evaluations for our officers to move towards a more qualitative standard. It's difficult, removing the old guard from policing is a challenge that we and the job have to embrace. Not removing the old guard, but changing that old guard attitude of how many numbers of tickets, how many numbers of arrests have you had? That means you're a good cop or a bad cop. We need to do away with that. And legislation in favor of that is something that I support. Sometimes that legislation will drag that old guard kicking and screaming into the 21st century, and we need that. The oversight board itself is my primary opposition against this bill, sir.
So you're okay with banning quotas, but you prefer to have the current solution have more time?
Yes, sir.
Okay, thank you.
Vice Chair.
Thank you, Mr. Chair. I just have a couple of questions, Mr. Doherty. You said your main objection is the board. I mean, why are you opposed to the board?
We already have a board that's been constituted, ma'am. This board in particular is comprised entirely of community members, which does not always add context. The board that's been established this summer, which has not had a chance to function, which we did not oppose, is comprised of 4 community members, 1 from each of the main jurisdictions that WMATA supports, 1 at-large member, and 3 members of law enforcement who are specifically prohibited to be affiliated with the Metro Transit Police Department. I think that having a board with those members of the police who can offer context to certain uses of force, to certain actions taken by officers is helpful. One of the biggest things I'm pushing with these committees and these reform demands that we've made on the department is more community involvement so that we can hear from the community as to what their, how the community views our actions, but also so the community can gain some context from law enforcement as to why certain actions may look reprehensible, but were in fact in keeping with the use of force or response that was needed at that time, ma'am.
Does this proposed, this legislation has community members on it? Is that right? Or
that's my understanding, ma'am.
Okay. Thank you, Mr. Chair.
Yes, ma'am. Thank you.
All right, thank you very much. Are there further questions for the witness? Seeing none, that concludes the testimony for House Bill 666. Thank you
for your time.
Much. Thank you. Okay, now we are going to move to Delegate Wells. Delegate Wells is House Bill 194. Oh, I see what we're doing here. Okay. I'm going to call on Delegate Wells for 3 minutes, then Stanley Mitchell for 2. Natasha DeTarget, I mispronounce the name every time. So DeTargue, probably wrong. Celia Plant. We'll hear from all of them. The witnesses for 2 minutes, the delegate for 3. There's 1 person here to testify in opposition. So Delegate Wells, if you would like to begin for 3 minutes.
Okay, thank you, Mr. Chair, and members of the committee. For the record, my name is, I'm Delegate Melissa Wells, and I'm here to testify on HB 194, which would require police officers, public defenders, and I also have an amendment to include state's attorneys to undergo implicit bias testing and training. And I've had several conversations, and after those conversations with various stakeholders, I will also be putting forward an amendment to remove the evaluation piece, as well as a measure to have the results put online so that I can work with those organizations to truly define the parameter of the evaluation. In 2020, we witnessed millions of outraged American citizens take to the streets in protest against police brutality facing Black and Brown communities. The murders of Breonna Taylor and George Floyd were a tragic reminder for so many that our criminal justice system is broken and needs serious reform. Citizens pleading for accountability and an end to unjust police violence is nothing new. The system is clearly broken and there is no one simple solution to fix it, but that should not prevent us from doing everything we can to make it better. Everyone has implicit biases, and I'm not saying one piece of legislation would put an end to this bias. However, it is clear that some have much stronger internal biases to the point of these individuals being a danger to others. I think we can all agree that anyone with a strong recognizable bias against a certain group might not be the best protector of that group. An officer's duty is to protect, a public defender's duty is to represent, and a state's attorney's duty is to enforce laws in a just and unbiased manner. By simply being able to identify potential unconscious bias, the system can better serve the people they swore to protect. I ask that you support these steps outlined in the legislation to ensure that our collective voices can translate into collective change. And with that, I ask that the committee offer a favorable report on this bill. Thank you.
All right, thank you very much. We're going to go now to Stanley Mitchell for 2 minutes, please. We're looking for Mr. Mitchell. All right, we will come back to Mr. Mitchell, and we will go to the person whose name I have butchered again, and I apologize. Natasha Dutargue?
Artigue.
Artigue. Okay, I'm very sorry. I'm writing it down. I apologize.
Good afternoon, Mr. Chair, members of the committee. My name is Natasha Dartigue. I serve as the Deputy District Public Defender for Baltimore City. I am present here today to encourage you to return a favorable report to House Bill 194, but also I am available to answer any questions you have in regards to this particular issue. The Office of the Public Defender has been for several years now in the onboarding and continuing education process of our attorneys, included tests and training for implicit bias. We think that is fundamental to the goals that we share with our shareholders, which includes the state's attorney's office in promoting greater trust from the community in our criminal justice system. Thank you.
Okay, well, let's see if Stanley Mitchell is here now. Stanley Mitchell? All right, I don't see Stanley Mitchell yet, so we'll come back to him again in a moment. And we'll go now to Cecilia Plant.
Good afternoon, Mr. Chair and Madam Vice Chair and members of the committee. My name is Cecilia Plant, and I am the co-chair of the Maryland Legislative Coalition. And I want to thank you for the opportunity to testify for House Bill 194. The Maryland Legislative Coalition is in support of this bill. We are a coalition of citizen activists from all over the state, and we are very interested in all the bills related to policing this session. And we are particularly liking this bill about implicit bias training. We believe that implicit bias, as Delegate Wells mentioned, is something that everyone has. It affects how we deal with people. It affects our level of patience and our capacity for empathy, all of which are required when dealing with the public. For people of color, people who do not speak English, people with disabilities, and other folks that are marginalized, their experience when dealing with law enforcement and public defenders is very much affected by implicit bias. We should consider this bias very seriously because it can seriously affect someone's life. This bill would require testing for implicit bias for both public defenders and entry-level law enforcement officers. And we feel that it is important for this to happen, and we urge a favorable report. Thank you very much.
All right, one last time. Stanley Mitchell, are you there? Okay. Don't believe he's with us, so we'll go ahead to questions. Are there questions for the panel? All right, Delegate Ron Watson, please. Delegate Watson, you're going to have to unmute yourself. And was probably an insightful question.
I was just practicing.
That's important.
Delegate, my question is the implicit bias training, is it an annual event or is it a one-time event when folks first start their service?
Natasha, would you like to elaborate on that?
At the Public Defender's Office, when we conduct trainings, it's a combination of both. It would be my suggestion that that would be the part of the bill, that the training would be something continuous, as this is a growing area of discussion and research. So as the discussion continues and the research continues, I think it's also important that there's continuing education on the subject.
Thank you very much. I hope you'll give that strong consideration.
Are there further questions for the panel? Seeing none, thank you very much. We'll go to the one who has signed up in opposition. That's Stephen Kroll. Mr. Kroll is probably not on just yet. There he is. All right, Mr. Kroll for 2 minutes.
Mr. Chairman, members of the committee, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, Executive Director of the Maryland State's Attorneys Association. I've been prosecuting cases since 1984. Let me say this. We are for, I repeat, for implicit bias training. Why I'm opposed to this bill as written. I am not opposed to implicit bias training. In fact, as most of you know, I've been doing the implicit bias training for MSA since 2017. Yes, me. Now, what I'm objecting to is the timeline here. Now, if the delegate who has sponsored this bill wants to get rid of the evaluation process and the testing process and the posting process, I'm all for it, because we're doing what the bill already says to do. We agree we need to have implicit bias training. But this bill was requested on July 9, 2020. It was first read in January 13, 2021. And it wasn't until February 9, 2020 when I inadvertently hear that the MSA or state's attorneys would be part of this bill. So this is legislation by surprise. I have to go to my board, which won't meet again until March, in order to get funding, which I will need for evaluation and testing. I can't do it by then. I can't get a fiscal note by then. It's really not fair to me or the MSAA. State's attorneys are county employees. They're not state employees like the public defender, the attorney general, or the state prosecutor. If you ask anyone who's involved in training, they will tell you implicit bias training is important, and we have led the way in implicit bias training. And I'm happy to share with you everything that we've done since 2017 when it comes to this important issue, and it is an important issue. I'm not sure if the sponsors even talked to a local state's attorney in Baltimore City about what we're doing when it comes to implicit bias training. I'm just not sure at this point in time. But I can tell you that we are making it a point to train everyone continuously. It's that important of a subject. And what we're doing it by is by what's called awareness. The more we make our prosecutors aware of what they're doing and what they're not doing, the better it is for everyone from there. We object to the testing. I'm happy to go into why we object to it, but if the delegate is willing to amend of no evaluation and no testing, we agree. Implicit bias training is important. I'm happy to tell you about things that we have done. I'm happy to tell you about testing that we have done and what we can't do. But the delegate is again ready to amend it. And the problem is I haven't seen any amendment.
Mr. Kroll.
Last week, I've not seen an amendment. So for those reasons, I oppose it, but I can assure you we will continue our journey for implicit bias training. And I'm happy to answer your questions.
Thank you very much. Delegate Deborah Davis.
My question is for Mr. Kroll. Thank you, Mr. Chair. My question is for Mr. Kroll. You've said we in our several occasions. Have you had implicit bias training?
I have, and I've taught it in this MSA since 2017, and I'm happy to invite you, Delegate Davis, to our training on it. I'm happy to come down and do the training that we give for you. I think you'll like it.
For the record, no, thank you.
Vice Chair.
Well, since you've taught it, Mr. Kroll, can you tell us what does your implicit bias training entail?
It talks about the history of implicit bias. It talks about the triggers that, in fact, impose implicit bias. It talks implicit bias in the courtroom, how to prevent it from there, and it gives awareness. Quite candidly, the chair has had it in its early stages, and seeing is believing. Like I said, I'm happy to tell you all about it by showing you what we do. It's easier said than done.
Is there any type of testing so that people can become aware of their implicit bias or realize that they have an implicit bias?
We've had Professor Russell McLean from the University of Maryland, who's come forward and done our training for us also. We're also having Adam Voss come forward. I welcome to look at both Professor McLean and Adam Voss up then. So as far as the testing is concerned, bias is so subjective, it's very hard to test on it, but I can assure you that all the training that we've done, from every state's attorney, they've gotten something out of it from their awareness of what they're doing and what they're not doing.
You're going in and out a little bit, but what I'm getting is no, there's been no testing.
No testing.
Okay, thank you.
Delegate Wells, I have a question. I'm going to come back to you here for a second. Is there a peer-reviewed test for implicit bias that is available?
Well, I'll double check. I mean, I know that the test that is used is the Harvard test. That's my understanding, or maybe I might have that. Let me make sure I'm using the word test. Yes, that's the way to test it. But what we do not have a peer review of is the evaluation. And so that's why we are removing the evaluation piece from it, because there's no consistent way to evaluate across all. So public defenders, state's attorneys as well. There may be ways for us to be able to kind of assess police officers, but because the bill is applying to more than police officers, we are pulling back so we can have conversations with stakeholders to begin to identify what would be the best way to begin to look at evaluation.
All right. Are there further questions for this panel? I'm sorry, my screen just went bonkers. All right. Seeing none, thank you very much. That concludes the testimony on Delegate Wells's bill, and that is House Bill 194. We're going to go now to House Bill 728, and that is Delegate Moon's bill. Delegate Moon's going to testify for 3 minutes, then John Giannetti, Sarah Little, Jessica Spiegel, Crystal Williams will speak each for 2 minutes. So we'll go with that. So Delegate Moon for 3 minutes if you'd like.
Sorry, and you said we're doing 728, not 720.
I mean, what's your pleasure? Would you prefer?
Well, whoever's in the room is fine.
Well, we'll
I
do
just want to make sure that it was
728.
728 in the room,
I
not
think we
720.
I see Ms. Spiegel, I see Ms. Little. I don't see Ms. Williams. And I don't see Mr. Giannetti, but you've got 3 minutes. So if they don't get in, Giannetti is coming in. And we don't see Ms. Williams. So in any case.
Right, that's fine.
All right.
So House Bill 728 is a new one for me. This is a bill that came in by request of the public defenders and Senator Lamb, who most of you should know is a physician. And look, the language has an amendment coming. So I just want to get you to focus on what the policy problem is that's been presented. And basically, it deals with people who have been committed and found criminally not responsible by a psychiatric reason. And what the effort is to amend what the release process procedure due process rights are involved in this, including things like who can file an exception or objection at various stages of this process. And so at heart, there are a few problems that were presented that are trying to be solved here. But one is to just simply have a clear process where someone could be part of a community release plan and not have a third party who had really nothing to do with this objecting along the way and creating more of a predictable timeline. So that's among the problems that are attempted to be solved here. The language was coming in sort of late, so I apologize. There will be amendments coming, but let me turn it over to some panels to fill in some of the rest of the details, and then maybe we can get into a discussion. Thank you, Mr. Chair.
All right, we'll go ahead to John Giannetti.
Thanks, Mr. Chairman, Madam Chair, Madam Vice Chair, members of the committee. John Giannetti for the Maryland Criminal Defense Attorneys Association. And our organization, Criminal Defense Attorneys Association, involves all criminal defense attorneys, including we have many, many members of the Office of Public Defender. And I'd have to tell you, the Office of the Public Defender is the one that's been carrying the water on this one and doing the heavy lifting. So what I've come to say is that the board of MCDAA supports the efforts that has been spearheaded by Senator Lamb, Delegate Moon. Thank you very much for putting in this legislation, but also the Office of Public Defender. And in philosophy, the idea is this: our laws already allow for an individual who's found not criminally responsible for a crime to be committed. Now, the question is how do they enter into the public once again? And this bill seems to have the right idea and focus. And what it does is, in many times, and during my 25 years of practice, I've had two clients who were found not criminally responsible. And unfortunately, by economics, every single time that a person is found not criminally responsible, that private attorney is no longer representing that person. And it's oftentimes the burden of the Office of the Public Defender. So what this bill does is this makes sure that the Office of the Public Defender gets notified. It adds extra notice requirements, and it also makes sure that the individual who's having an evaluation can get that evaluation. And really, as public policy, as a society, if these individuals are ready to go back into the public, there's nothing wrong with having them evaluated. There's nothing here in this bill that makes it automatic. I don't even think that, the amendments aren't going to make it automatic. So it just allows them to get the reviews. It allows the process to go forward in an orderly fashion. And we asked the committee to look carefully at the amendments, but to pass this bill in philosophy, we agree with it. Thank you, Mr. Chairman.
All right, we'll go now to Sarah Little, please, for 2 minutes.
Thank you, Chairman Clippinger, committee members. My name's Sarah Little. I'm an assistant public defender with the Public Defender's Mental Health Division. I represent individuals committed to Springfield Hospital Center in Sykesville. House Bill 728 is proposing a number of changes. I'm going to address two. First change would bar a party from filing exceptions to a hearing at which they didn't appear. Right now, individuals seeking release, the health department, the state's attorney, they all have the right to appear at administrative hearings, and that's the main venue for the majority of cases. And all parties currently have the right to file exceptions regardless of whether they participated in that hearing. At the court reviewing those exceptions, they are limited to the testimony actually taken at trial. No new evidence can be taken. And so to permit a party who did not appear at an actual hearing to argue against the outcome of a trial on the merits, this leads to real and practical costs. Non-dangerous individuals who are ready for release face months and years of confinement in the most restrictive setting, with the average cost of inpatient state psychiatric care at almost $800 per day. Every day of delay costs the state in real dollars, and the availability of precious bed space for acutely mentally ill Marylanders. A second change proposes to allow civil rules of discovery to be applied in all conditional release hearings. This balances the individual right to due process and a full presentation of evidence with the realities of a system that doesn't provide the options of these sorts of discovery processes outside of a jury trial. And so I ask that the committee issue a favorable report of House Bill 728. Thank you.
Jessica Spiegel, please. Jessica Spiegel.
Hi, I'm Jessica Spiegel. I'm one of the social workers in the mental health division at OPD, and I'm going to speak to how the notification of potential violations to our office would provide us with the opportunity to intervene and assist clients in negotiating challenges that don't necessarily require a psychiatric hospitalization. Some of those examples include transportation issues, insurance lapses, a medical issue that requires hospitalization, lack of internet access for telehealth appointments, or even issues with a housing provider, including a flood requiring a client to be moved urgently to another location. These are all examples of technical violations that have resulted in a violation of conditional release, a hospital warrant being issued, and rehospitalization. The state hospitals are often used as punishment rather than treatment. I worked in one of these hospitals for approximately 3 years, and I saw many individuals violated due to their substance use. So they are sent back to the state hospital, and unfortunately, they're unable to receive substance abuse treatment while in the hospital due to short staffing and wait lists for such treatment, when in reality, they could have stayed in the community and accessed treatment much faster and for much less of a cost. Our clients face increased stigma due to their mental illness. And I would just like to note in the testimony last week by the state's attorneys, they argued that this bill would lead to the release of murderers and rapists. And anecdotally, I can tell you that we see more NCR cases for less serious charges, such as disorderly conduct, destruction of property, and assault. And I don't believe that's a fair assessment of our clients. Their mental illnesses came first and must be met with real treatment rather than punishment. Thank you.
All right, thank you very much. Crystal Williams, please.
Yes, good afternoon, Chairman Clippinger and members of the committee. My name is Crystal Williams, and I'm the Director of the Government Relations Division for the Office of the Public Defender. Just about every aspect of a patient's life can be regulated by conditions of release. Conditions of release can control where patients live, who they live with, whether they can work or go to school, where they can work or study, who treats their mental illness, and how they receive their medications by mouth or injections, and what medications they take, who they associate with, and more. Applications to extend conditional release are not trivial matters. They significantly impact a patient's liberty interests. Under current Maryland law, the Department of Health, the state's attorney, or the patient can make an application to change the conditions of release. The department or state can file to extend. The patient can file to shorten the conditional release. The current statute does not specifically provide for hearings in these cases. And while many judges across the state hold hearings in these matters, others do not. Judges who refuse to hold hearings upon request of a party deny the parties the ability to provide testimonial evidence to support the allegations in their own application or to refute the allegations made in other parties' applications. Denying a patient the opportunity for a hearing in which the patient can present testimonial evidence by their community mental health treatment providers, medical experts, or other relevant witnesses to refute information contained in the Department of Health or state's attorney's applications affects their ability to effectively advocate for their liberty interests. Allowing hearings upon request serves the interests of the Department of Health, state's attorneys, and patients. This bill also clarifies that conditional release can be extended for not more than 5 years. Judges across the state interpret the language in Section 3-122 differently. Some agree that conditional release can be extended for any time period up to 5 years based on language in Section 3-118, which states that the court may not continue the conditions of a conditional release for more than 5 years. And some interpret the statute to mean that the extension must be for 5 years because 3-122 states that upon consideration of application and evidence, the court can extend the conditional release by an additional term of 5 years. And so for all these reasons and for the reasons highlighted by my colleagues here today, we urge a favorable report on this bill. Thank you.
All right, thank you very much. There is a question for the panel, but I kind of want to take us back here just a second to go to the point of the bill. So we're dealing with the release of people who are found not criminally responsible and a threat to themselves or other people, correct? So they've been held at the Department of Health or through the Department of Health, and I'm not using the exact, I apologize for not being 100% precise. I've got criminal procedure in front of me and I'm just refreshing my recollection, but I'm looking now at Ms. Little. Help me out with where are we in the story? So go ahead.
Yes. So the long and short of it is these are individuals who at least at some point in various sort of permutations were found to have a mental illness and to be so dangerous that they required inpatient confinement. So that would be the universe how folks end up inpatient in a facility. There's a universe of folks that are found MCR that are released directly from court or that are in the community.
Because they're not found criminal, they're not found to be a threat to themselves.
Exactly so, or they're under conditions that arguably render them not a danger. So all of the different proposals that we're talking about in terms of the actual release hearings. So these are the changes sort of in pages 1 through, let's say, 3 or 4 of the bill are involving folks that are currently confined. The changes to the issue of the hospital warrant, the changes to the applications for conditional release impact individuals that are out in the community. So we're kind of talking about 2 different populations of folks. So the aspect that I spoke on in terms of the conditional release, the exceptions hearing, these are hearings that occur for people who are being confined in the hospital. So you would be correct that there was at least an allegation made that they're so dangerous. The issue that Ms. Spiegel is talking to and where this intersects is that the reality is, and I have personally been involved in a number of these cases, most recently just a few months ago, there are individuals that are brought in on hospital warrants, and the allegation is that they are actively dangerous. The finding is actually that they are not, and in many circumstances, it is for very technical violations that in theory could be remedied, and I personally have remedied by, if I have sufficient notice, moving to quash it, reaching out to providers, sort of trying to figure out if the issue is just they need to update their address. Let me make sure that the address is updated. Let's fix this. Let us not waste a hospital bed on an individual who is not actually mentally sort of experiencing symptoms. Let us really reserve confinement for those individuals that are truly going to have the need. And so there are different issues depending on the universe, but what the long and short of it comes down to, you know, the ability to really effectively advocate for the clients, but also to make sure that we're using the precious resources we have judiciously and that they're going for folks who truly need them.
I could go down and ask a bunch of other questions, but let's get Delegate McComas's question in here. Delegate McComas?
Thank you, Mr. Chair. I'll just be brief. One of the folks, and maybe it was Ms. Spiegel, said that basically you could let folks go out into the community because there's enough protections in the community and make sure that these people stay on the right path. I guess I have always kind of had the experience where a lot of folks don't want to take their medication, that they can be schizophrenics because they don't like the way they feel, or they can't, you know, drink and drug and also take the medication. Same way with manic depressives, that once they start feeling good, they stop their medicine because they don't need it anymore because they're feeling good. So then the cycle continues. The other thing I was kind of concerned about is, you know, nobody's going to be able to observe these folks 24/7. So a lot of them, you know, have issues that there may be a little bit antisocial. And the other thing I wanted to know is, what if they have personality disorders? And those are very, very, very difficult to treat. The borderline personality disorder, the antisocial, So I kind of wondered, how can you kind of guarantee that outside is better than inside? Because I just don't see how you can, when they're difficult folks, they're challenging mental health patients and they're challenging clients.
Thank you very much for those questions. I would say as a preliminary that we are not proposing with these changes to change the fundamental scheme, which in Maryland allows any individual who's found not criminally responsible and is confined inpatient. Every individual who's found NCR has a right to seek release, and the current scheme allows them to achieve that release, typically with conditions, if they can demonstrate by a preponderance of the evidence that they wouldn't be dangerous to themselves or others. And the trier of fact has to make that finding. The state's attorney is a party to the case. The hospital is a party to the case. So there's an absolute long enshrined legal process to sort of vet the issue of whether a person, as you've pointed out, a theoretical individual, could actually be safely in the community and what conditions would render them able to be safely in the community. The question of the practical realities you bring out, it's a good one, it's a reality, but the reality is that these conditions are quite stringent in most cases. Initially, again, it's anecdotal in what I'm describing here, but most folks, the initial level of care when they leave the hospital, in the vast majority of the clients I've represented, and I've been doing this now for 9 years at 2 different state psychiatric hospitals, involves 24/7 supervision, at least initially. Or intensive levels of supervision, meaning awake overnight. They are monitored by a social worker, a licensed clinical social worker, who is with the Community Forensic Aftercare Program, who receives reporting forms from providers in the community. Again, in practice, the vast majority of individuals that are conditionally released have to live in supervised housing. They have to go to a day program. They have to go to a clinic. They have to take their medication. If there are any deficiencies in their compliance with the conditions, this is what opens up the universe of a hospital warrant, of having those conditions revoked, of being returned to inpatient confinement. The issue of a personality disorder, certainly the whole individual has to be looked at, but in Maryland, you cannot be found not criminally responsible on the basis of a finding of a personality disorder. Really, you have to show that the primary issue is a major mental disorder, as you mentioned, like a schizophrenia or a bipolar disorder. So certainly it's a part of the consideration. And listen, it may prove to be a barrier to someone's ability to prove that they may be released. Because again, the burden is on me, on my client, to show that they could be safe and that they will have those services and follow them. So it's of course a concern how folks actually are able to live and treat their illness and be in that less restrictive setting. But for purposes of this bill and what we're proposing, it's a universe where we're talking about folks who will have, in theory, been able to prove that by a preponderance of the evidence.
And if I could just speak to answer your question about just releasing people, I was speaking about specifically people who are brought back on their conditional release because of substance abuse. And I've seen this many times where they're brought into the hospital, they're psychiatrically stable, or they become psychiatrically stable pretty quickly, but they have to wait in the hospital on a wait list where there's 5 substance abuse counselors for 370 patients. And they're not allowed to proceed with conditional release because they need to complete that within the hospital. So that's what I was speaking of, that there are more treatment options actually available to them in the community, but they can't access them.
And if I could just say one quick response also, just to balance the very generic policy perspective here. Again, this is not my area of practice or anything like that, but if you recall, the Hogan administration was almost hauled in for contempt of court not too long ago because of a shortage of psych beds. And sort of the part of the compelling testimony the last time this bill was brought around, I think this might be a first in judiciary, but in the Senate, was that it's not free to do this. And so right now you're having a situation where there's an administrative proceeding for this, NCR designation, people aren't showing up to make any claims about that. A determination is made, and now here they are filing these frivolous appeals. And the cost estimate here is that this is $70,000 every 3 months for this additional care. So again, it's not free to do this. So there has been a determination made. And part of this is about whether you're just going to let people throw monkey wrenches into that process and cause delay that is not going to be fruitful at a cost of $70,000 every few months to taxpayers. So just got to balance the resource interests.
All right, are there further questions for this panel? Seeing none. Thank you all very much. We're going to go to those the person signed up in opposition. Thank you all very much for your testimony. We'll hear now from Scott Schellenberger for 2 minutes. Mr. Schellenberger is just now entering. Mr. Schellenberger for 2 minutes, please.
Great, thank you so much. I'm here in opposition to House Bill 728, and I do need to correct a couple of things that I think are just a little bit off. Number one, it was stated that the state's attorneys, once the person has been found not criminally responsible, doesn't really have any interest in the case anymore. Well, that couldn't be further from the truth. Remember, the people that we're talking about here have committed a crime in my county, and they have filed a plea of not criminally responsible. And either our assistant has agreed that they are not criminally responsible and agreed that that's the way it should go, or a judge has found them, or a jury has found them not criminally responsible. And while I do concede what my friends in the public defender's office said, some of these cases are lower level. If you're going to one of these institutions, more likely than not, they are concerned about your violence. And so you've committed a crime, you're not criminally responsible, and now you're going to inpatient treatment. They've passed the outpatient, you're going to inpatient treatment at one of these institutions. Now what happens? You stay there until the health department thinks you are better. And if they think you are better, they have a hearing. At the hearing is the administrative law judge, the public defender, and importantly, the attorney general's office. And that is why very often state's attorneys do not go to these hearings, because they are well represented by these other parties, namely the health department saying whether they're dangerous or not and can be released. And of course, the attorney general's office, who's generally representing the same similar interests. Now, what the public defender's office and this bill is mainly complaining about is the law allows me in Baltimore County to appeal that decision of letting this person out, even if I wasn't at the hearing. That's one of the main complaints. And it just seems a little crazy, particularly when you consider, again, what I've said before. You commit a crime out in Western Maryland, a kidnapping or a murder, or it could even be something even simpler. And now you're having a hearing at Clifton T. Perkins. And unless the prosecutor from Western Maryland comes to Perkins, not once, not twice, but once a year, you can keep asking for these hearings. They got to keep coming. So my main point is it's a problem with resources. The other thing that I find interesting is they want to cut the state's attorneys out until you get to the on page 6, when you have to get a hospital warrant. Now you've been released into the community. The state's attorney didn't appeal or lost at the court hearing. And now the health department is saying you're violating your conditional release by doing something wrong. And oh, by the way, they're in your county, but we won't get a hospital warrant unless the state's attorney on page 6, number 6, writes an affidavit. This statute has been in place for a long time. It's been working well. I will concede with my friends in the public defender's office that the discovery request that they make, I think that's entirely reasonable. They should get all the paperwork that they would normally get, but it just seems a little vengeful to say, because I don't drive all the way across the state to go to a hearing, I don't have a right to complain about what happened at it, particularly when the crime happened in my jurisdiction. So I believe House Bill 728 should be given an unfavorable report, and I appreciate your time.
Are there any questions for the witness? Delegate McComas, your hand is still up, but it was up from before. And we can't hear you anyway. So did you have a question, Delegate McComas?
So I was just going to ask Mr. Schellenberger if the fact that, we're all using Zoom now, if they were allowed to have a Zoom and weigh in and, stay in Baltimore County and not have to go to Perkins, would that work? So you guys could weigh in?
Well, certainly I will concede that I counted the other day. I have not taken 60 trips down to Annapolis to see you all this year. And so, yes, this does work. And yes, that is a possible issue. I can tell you that these files from the health department are very thick and extensive. There is a lot of discovery. I see my friend Delegate Moon, who I'm supporting on his next bill, smiling. But I think that is a potential. It's just we're now attending a hearing that we've never attended before. Remember, some of the counties like Dorchester County have fewer than, I believe, 10 assistants. They're already, some of the smaller counties are stretched thin, but certainly you have a very practical point of view.
Okay, are there further questions? Seeing none, that concludes the testimony on House Bill 728. We thank you very much for that. Mr. Schellenberger can hang on because we're going to House Bill 720. We're going to hear from Delegate Moon again for 3 minutes, Mr. Schellenberger, Yosefi Seltzer, Jake Burdett, John Myers, and Debbie Feinstein. Then there are people who have testified, who are signed up to testify favorable with amendments. We'll hear them separately. Very much for that. So we'll encourage people to mute their phones or mute themselves, and then we will begin with Delegate Moon for 3 minutes, please.
Thank you, Mr. Chair. Colleagues, this might be a new one for us to toy around with, but it's basically a bill to modernize our two-party consent and wiretap laws in Maryland. Famously, you might be thinking about the Linda Tripp, Monica Lewinsky case as the sort of classic example of not getting consent before taping them, but we've actually had more recent cases. If they're here today, you'll hear from one that involved a college student bringing a phone camera into a meeting with a politician and taping them, subsequently being charged with a felony. And so this is where part one of this bill comes into place. What this bill does is it takes the current penalty for this offense, which is 5 years and a felony, and knocks it down to 90 days and a misdemeanor, which I think is far more appropriate and in line with how we've put a lot of other nonviolent offenses, how we've ordered the penalties there. The second part of this then deals with, after we get through the penalties, when, if ever, can this type of evidence be brought into court? And so right now, if you obtained one-party consent evidence in a state where it was legal, you can bring that in. And so this would take an additional exception and say, if it was a serious crime that you have evidence for by this taping, we're going to let that in. And so I will concede, again, in the amendment realm here, we had tried to talk about what crimes exactly would warrant allowing this evidence in for. We originally tried to make it crimes of violence and domestically related crimes, but those of you who have been in work sessions on the term domestically related crimes knows that opens a huge discussion about how to write that if you're trying to bring those cases in. And so there's further conversation to be had about how to do this. But our intent is to say, if you capture evidence of a crime of violence, at least, you ought to be able to bring that evidence into court. So that's the bill at heart. Happy to answer any questions.
All right. The shock of the committee again, now in favorable with Delegate Moon. We don't know what to do. Scott Schellenberger.
Delegate Moon, so happy to 2 times in 1 year be supporting one of your bills. House Bill 720 is a time that is a bill that should have come a long time ago. If you go back and look at Courts and Judicial Proceedings Article 10406, they mention switchboards. That's when that statute was written. So that statute is Maryland's wiretap statute, and as Delegate Moon indicated, we are a two-party consent state. 38 other states are one-party consent states. I would think we should move in that direction, particularly in light of how many people, as soon as they see something wrong happen, pull out one of these phones and start recording. But in the state of Maryland today, if I did that, I'd be committing a felony for which I could go to jail for 5 years. Think of how many people are violating that law every day right now by hitting record. So I think the first very reasonable proposition that Delegate Moon has put in there is making it a 90-day violation. Because honestly, while I wouldn't mind being a one-party consent state, there are a lot of other people who think we should still be two-party. So why not make the penalty a misdemeanor and 90 days? But the most important part of this statute is creating the exception for domestic violence. I cannot tell you how many times my prosecutors have a victim to a domestic violence case and either have recorded the violence themselves or recorded a confession from the person who committed the violence. And when they walk into our office and say, "Let me play this for you," in Maryland, we have to say, "Stop. If you play that, you will commit a felony in front of me." That is just ridiculous in this day and age. I mean, in this day and age, people are recording everything. And therefore, I think that that's the most important thing. And I understand, and I'm willing to work with folks on the definition of domestically related crime. We can get there, but in these kind of cases, we need to have what this century and this decade have brought to us, and that is bringing the best possible evidence to court. By the way, that statute works both ways. When a defense attorney comes up to me and says, "I got a video, I got a recording, audio recording of your victim telling my client it's a lie," guess what? They can't play that either. So it works both ways, and that's why House Bill 720 is an excellent vehicle to solve this decades-old problem.
Thank you very much. We'll hear now from Yosefi Seltzer, please, for 2 minutes.
Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. My name is Yosefi Seltzer. I'm an attorney at the JAG office at Fort Meade, and I'm speaking today in support of House Bill 720. I'm here on behalf of my clients who are victims of domestic violence. Some are service members, others are military spouses. The current two-party consent law creates a chilling effect that intimidates victims of domestic violence from coming forward. As you are probably aware, prosecuting domestic violence is extremely difficult. The abuse often takes place in the home where there are no other witnesses. Sometimes the victims are young, disabled, elderly, or speak languages other than English. The abusers threaten and intimidate by telling the victim, "No one will believe you." The current law also prevents judges from considering whether to admit audio recordings that could be helpful in deciding guilt or innocence. Maryland is behind the times. The federal wiretapping statute and military rules of evidence, along with 38 states and the District of Columbia, currently have one-party consent laws. Current law also creates a conflict with federal and military prosecutions that take place in Maryland. Although audio recordings are admissible in federal and military courts, they still violate Maryland law and therefore force federal and military prosecutors to question whether they should put victims and witnesses in jeopardy of state prosecution. There was a time when various forms of evidence, such as nanny and security camera footage, fingerprints, and DNA evidence were debated. If authenticated audio recordings are available, shouldn't a judge be allowed to admit and hear them when evaluating witness credibility and deciding guilt or innocence? Isn't that a more accurate process to get to the truth of what happened than deciding simply on witness testimony alone? Let's also not forget that domestic violence survivors have civil rights and civil liberties and deserve to live free from violence and fear. Saying it another way, abusers should have their safe harbor to perform abusive conduct eliminated, and domestic violence survivors should instead receive a safe harbor to present recordings of their abuse. Thank you for your attention. I welcome your questions.
Thank you. We will go now to, we will go now to Jake Burdett, please, for 2 minutes.
Good afternoon, Chair Clippinger and members of the
We
House.
will need you to turn on your video. There we go. Great.
My apologies. Yeah.
No
Good
problem.
afternoon, Chair Clippinger and members of the House Judiciary Committee. I'm testifying today in favor of Delegate Moon's bill HB 720. My name is Jake Burdett and I live in Howard County, and I'm a 22-year-old recent graduate from Salisbury University. In 2018, during my time as a student on the Eastern Shore, I was involved in a high-profile controversy when I attended a protest against Maryland's 1st Congressional District Representative Andy Harris at his Salisbury office. This was not a protest that I organized, and I was just a 20-year-old student activist going to live stream the event, as is pretty typical at protests and direct actions. I was not aware of Maryland's two-party consent law and requiring people's permission to be recorded. So when I live streamed the action, Harris's office ended up pressing 2 felony charges against me. 1 charge for the recording of the protest and 1 charge for the distribution, since the recording was a live stream on Facebook. I was facing 10 years in jail and potential fines of over $10,000. And as a young student who was doing well in school, I felt trapped into accepting a plea deal rather than risk the jail time if I tried to fight the case and lose. I accepted a 3-year probation before judgment offer that I'm still on to this day. In addition to the probation, I also had to complete 100 hours of community service, pay hundreds of dollars in legal fees, and still face employment discrimination to this day from the felony charges. I'm not here today to argue about the morality or legality of what I did at that protest at Representative Harris's office that day. Rather, I'm here to ask the question, did the punishment I was facing fit the alleged crime I had committed? That is the question that this bill addresses. It does not make it legal to record people without their consent. Rather, it just reduces the penalty for doing so from a felony to a misdemeanor and makes the maximum potential jail time 90 days rather than 5 years. I think this is a reasonable compromise and strikes a good balance between genuine concerns for privacy and making sure the law is not too punitive and doesn't prevent people from being willing to take a case to trial. And I urge committee members to vote favorably on HB 720. Thank you.
All right. Thank you very much. We'll go now to John Myers.
Good afternoon. Pleasure to be with you. I'm here in sunny California, in Davis, to be more precise.
There's no need to show off. There's no need to show off. Starting off your testimony very, very dangerously here.
All right.
So that's all right. We'll let you start again. 2 minutes. It's all right.
All right. Well, I'm here in overcast California then.
That's better.
All right. And I just wanted to say that I've been working on this issue for a long time. I'm a professor by trade, but a part-time lawyer for victims of domestic violence in our Superior Court out here, and a part-time minors counsel for children in high conflict custody cases. And my experience over many years has been that it is definitely disadvantageous to have the two-party consent law, which we had in California for decades. Fortunately, in the last 10 years or so, the California legislature changed it to a one-party consent law for victims of domestic violence so that they can now record what is clearly the best evidence of their victimization, and that can be used in court. I have personal experience as a lawyer with having my victims of domestic violence threatened that we'll take it to the prosecutor if you even consider using that evidence against the perpetrator in court. So I would applaud any step in the direction of allowing victims of domestic violence to utilize what Mr. Schellenberger quite clearly, correctly said is the best evidence.
Thank you much. And now we'll hear from Debbie Feinstein.
Good afternoon, Mr. Chair and Madam Vice Chair. My name is Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. My division prosecutes not only domestic violence, but also sexual assault, child abuse, human trafficking, and elder abuse. I would add to what's been said that not only are we talking about domestic violence cases, we're talking about sexual assault cases, some child abuse cases that count as crimes of violence under the current statute, and were the domestically related to be included. And I know that's a little bit of a legal configuration, as Mr. Schellenberger alluded to, that I won't go into right now, but even just adding the crime of violence definition under the public safety article would expand the crimes that would be included. I mention these other crimes because when we think about a child abuse victim or a sexual assault victim and domestic violence victims, these crimes occur behind closed doors where there are no witnesses. And the best evidence as has been stated before, may very well be these recordings. In addition, I would note that, frankly, there have been comments about the fact that it's possible then that the perpetrator would have the same ability to record. And frankly, that may be valuable for the prosecutors to review as well, particularly if there's been a false accusation, to be able to have all of the evidence, to have all of the best information about what went on behind those closed doors is a valuable tool that we do not currently have. I can tell you that just yesterday, I actually received an email in a case that has that's contemporaneous and going back to what Mr. Seltzer said with the federal government, with the military, where there's a concern that a recording in a domestic violence case, they'd like to use it in the military prosecution, but the victim is being threatened by the abuser that he will press charges against her or go get a citizen-generated complaint against her for violating the wiretap statute in Maryland if she brings this evidence forth. That is exactly the type of thing that we are trying to change via this bill, and thank you very much to Delegate Moon for his sponsorship. I would lastly note that on behalf of my boss, State's Attorney John McCarthy, he is in favor of changing our statute to one-party consent, that he has felt that for a long time, and I wanted to put that on the record as well for all the reasons that I've already articulated, and essentially to decriminalize the wiretapping as it currently stands, at least make it one-party consent for the delineated crimes as occurs in many other states. And I know that Ms. David is going to speak to that as well. So thank you very much, and I would urge your support of House Bill 720.
Are there questions for this panel? My goodness, yes, there are. We're going to go to Delegate Grammer, then Delegate Conaway, then Delegate Cardin. So Delegate Grammer to begin, please.
Thank you, Mr. Chair. Two questions for Mr. Schellenberger. So it seems like this is predominantly like an admissibility of evidence kind of thing, and the current laws basically block you from a lot of valid evidence in your cases. Is that the case here?
Yes, it not only blocks us, but it also makes it a crime.
Okay. So I guess the risk here is there's a lot of situations, and I guess the purpose of the law is in a lot of situations, you record somebody with the intent of damaging them, you put out a lot of personal information, and you can really just wreck somebody's life. Is that the purpose of the criminal offense?
Well, the purpose actually was decades ago was to prevent, the police from actually wiretapping phones. And that's why the statute is written the way it is it actually talks about when police can go plug into a switchboard. And, we just don't live that way anymore. You have the rules that you have concerning the police department, and we're not trying to change that. I would, however, remind everyone that this is exactly why we have body cameras, because we want to provide the best evidence. But we're looking for this exception for these violent criminals and for this domestic violence situation, because that is where it occurs a lot. And like I said, it comes both ways.
Okay. One final small question. So you removed the penalty down to 90 days. If I really just wanted to damage someone, I just eat the penalty. Is 90 days, if we're going to change the penalty, is that big enough? I'm usually not a person to even entertain this, but look, if I really wanted to get at somebody and I record them, I make it public, I get my 90 days and I just eat it. Is that really enough to be a deterrent to somebody to not do this purposefully?
Well, respectfully, you all over the last 4 years have been adding 90-day sentences to a lot of crimes that were a lot more before that. So I think 90 days is quite a bit. And again, when you say eat it, I understand that the person might be motivated to record something that they would believe would be damaging to the person. But once again, it's the truth. It's a record. So there are a lot of people out there who don't want to commit a crime and who don't want to even have a threat of 90 days. I think it would be a deterrent to the people who otherwise wouldn't commit a crime.
Okay, thank you for the answers.
Delegate Moon, very quick question before I go to Delegate Conway. Do you have a cross file for this bill?
Yes, this is Lee.
Senator Lee. Okay, thank you very much. Delegate Conway.
Thank you, Mr. Chairman. Thank you, Delegate, for bringing this bill. So, Delegate Moon, would this bill allow police body cameras to be recorded without the person being notified that they're being recorded?
Body cams, you said?
Yeah, for police body camera, you know how they're supposed to walk up to you and notify you?
Yeah, that's separate. It's separately, that's separately regulated.
So that wouldn't be covered in this bill?
No.
Okay, thank you very much.
Delegate Cardin.
Thank you, Mr. Chairman. Just a quick question for Mr. Schellenberger. Thanks again for being here. I know we've taken a lot of your time during these 3 months. If we did lower the penalty to a misdemeanor as you would like for this, would you allow a victim to play a recording in your presence or in one of your associates' presence, even if it's illegal?
You mean if their crime didn't come under those exceptions?
Yes.
I would be very hesitant to do that. Certainly the victim could be granted some type of immunity before they testified. I traditionally don't do that unless there's an extraordinary reason. I can only think of maybe 1 or 2 cases. I can tell you where we have done it. If we have a particular liquor establishment that is constantly serving underage drinkers, and the liquor board calls me and they need a 16-year-old to testify that they walked in and bought liquor there and nobody asked them for their ID, I have granted immunity to those individuals because that would have been a violation of the liquor laws. And that's only at the request of the liquor board because they're having a very difficult time with that establishment. That's really kind of the only time I can remember doing that. I would be very reluctant to offer some type of immunity or letting somebody violate the law in front of me.
What if a domestic violence victim had, bruises all over her face?
Well, it's not against the law to video record. And see, that's where we have to get into this modern time. So back when this statute was written, people weren't walking around with video cameras. And they certainly weren't walking around with video cameras that were this big. I mean, you had to have a huge movie camera. But so the statute only prevents audio recording.
Oh.
We've been able to video record and do that freely. And I can tell you right now, when police go to the house of a domestic violence victim, and if they don't have a body camera on, these officers are pulling their phones out and taking pictures of injuries. And that's perfectly permissible under the law right now. The thing that doesn't make sense is if they take their phone out and they don't have a body camera program and they record it, I can't play it in court. I can show the pictures, but I can't play the audio of what the person said.
Okay, thank you.
Delegate Watson.
Thank you, Mr. Chair. Mr. Schellenberg, I just have a question. I'm trying to grapple with this because in my world, I deal with FISA courts and all those kinds of things, right? And so, if the police wanted to get some kind of covert footage, audio, video, there's a mechanism by which they do that, right?
That's correct. If you go farther into the statute, there's very specific things that they have to do, either for me to get a wiretap, limited crimes, and I have to go in front of a judge. And as we talked yesterday, that's the one place I got to take an oath. So that's not covered by what this bill does. And then the place where certain crimes, they can do a one-party consent. Again, very limited, very specific circumstances. This concept is believing that the thing is being recorded, not involving the police whatsoever.
Not involving the police whatsoever. So somebody could covertly video or audio tape me doing whatever, and then use that against me for whatever and only see 90 days slap on the wrist?
Only if they did it because they were involved in a domestic related crime or a crime of violence, as the way the bill is written right now.
Oh, only those two circumstances.
Yes, sir.
So I can't arbitrarily put a bug in your office, just to see what horse you're betting on next week, right?
Oh, I'm sorry. Well, number one, not doing that. But number two, I now understand your question. If you violated this, you wouldn't be able to play it in court because it wouldn't fit the exception. But you are correct. The big punishment would be 90 days.
Okay. Thank you for that clarification. Appreciate
Yes, sir.
you.
Are there further questions for this panel? All right.
Mr. Chairman, I just wanted to make a brief comment.
Very brief, yes.
Yeah, regarding the body camera question earlier. Everyone should recognize that if body cameras malfunction or they're turned off accidentally or intentionally, the homeowner who's having their home searched could also benefit by being able to make their own recording of that search and that interaction with the police. So it does protect the individual potentially against improper use by the police.
All right. Seeing no further questions, that's the testimony in favor of House Bill 720. Thank you all very much. All right, so now we're going to go to those who would testify favorable with amendments. We'll hear from Sarah David for 2 minutes and Michael Lohr for 2 minutes. All right, Ms. David, are you on the line? There is Sarah David. There you are. And whenever you're ready, we'll start with your 2 minutes, please.
Great. Good afternoon, Mr. Chairman, Madam Vice Chair, and members of the Judiciary Committee. My name is Sarah David, and I'm Deputy State Prosecutor at the Maryland Office of the State Prosecutor, here to support HB 720 with amendments. Thank you so much, Delegate Moon, for sponsoring this bill to help victims of violence, particularly those who've had historical challenges being believed in our justice system. I'm going to focus on the second part of this bill, which creates an exception to the exclusionary rule of the wiretap statute. So general exclusionary rule, let's say from a Fourth Amendment violation, has exceptions, such as a good faith reliance on a warrant. This exclusionary rule has no exceptions. My office handles police misconduct cases and must grapple with the inadmissibility of wiretap evidence when presented from a citizen recording police. Other states who've had this restriction have excluded evidence where a person recorded their own murder and evidence from a child recording his own sexual abuse. The language for this exception to the wiretap exclusionary rule already exists in Maryland law through the hearsay rule. Hearsay is an out-of-court statement offered for its truth, and exceptions include statements where the circumstances of the statement make it reliable, such as something against someone's present, their own interest, or like a present sense impression, very much in line with the reliability of an audio recording. This language makes it so not all recordings are admissible if they violate the wiretap law, but a recording can be admissible if the party who's offering the evidence can show that the evidence is a material fact, the contents are more probative than any other evidence, and the interest of justice will be best served by this evidence being admitted. The evidence also has to be disclosed to the opposing party. To alleviate some concerns with immunity, we're supporting it with amendments so that it's limited to a criminal proceeding and replacing it being domestically related on the front end with, because those cases are labeled on the back end by prosecutors, with the public safety article. And these amendments have been discussed with Delegate Moon. Thank you for your consideration of HB 720, and we urge a favorable report with those amendments.
Okay, Michael Lohr.
Mr. Chairman, Madam Vice Chair, thanks for allowing me to testify. Real briefly, I just wanted to hit on some state comparisons because you may have heard there are 38 states that are two-party consent, but there are only 11 that are, there are 11 that are two-party consent and 38 that are one-party consent. There's also Vermont that has neither. This is all based on Title III of the Omnibus Crime Control and Safe Streets Act. This came after the Olmstead Act when they were wiretapping bootleggers. So this is how old we're talking about the statute. Maryland came along, and this was 1968 where they finally codified this at the federal level, but the feds have one-party consent as well. So keep that in mind. We have, out of those 11 states that have two-party consents. A lot of states already have similar types of carve-outs, exceptions within the two-party consent. As you heard, California recently carved out for domestic violence crimes. I urge you to read the paper that John Myers wrote, which is included in the written testimony. But let me just run through a few other states that have similar carve-outs. And just real quick, the amendments that Sarah David mentioned are certainly supported. I know Senator Lee supports those. And this year, I think the criminal aspect makes sense to confront. We would like to cross the Rubicon in one regard, though. I think if you have had a criminal proceeding and that evidence was admitted in a criminal proceeding, you shouldn't be unable to introduce that same evidence in a civil proceeding, such as a custody evaluation, a custody or visitation proceeding. It just makes sense if it's already been introduced in a criminal proceeding that you'd be allowed to introduce it in a civil. So there's a lot to chew on here. And I think maybe next year we'll have a separate bill dealing in the civil realm, but it might make sense to cross the Rubicon somewhat. But we do have Washington State, California, both have constitutional amendments, right to privacy. Senator Lee sponsored a constitutional amendment last year for the right to privacy. This bill does not cut into privacy at all. Delegate Moon obviously is a strong supporter of privacy. Washington State has a right to privacy, but they also say, notwithstanding subsection 1, wire communications or conversations of an emergency nature, such as the reporting of a fire, medical emergency, crime, or disaster, which convey threats of extortion, blackmail, bodily harm, or unlawful requests or demands, which occur anonymously or repeatedly, or in an extremely inconvenient hour, which relate to communications by barricaded. So anyway, just to name a few other states, Florida has a carve out, Pennsylvania has a carve out. There's several other states that have these carve outs. Happy to answer any questions.
Are there questions for this panel? Seeing none, thank you all very, very much. That concludes the testimony on House Bill 720. And we thank you all for your testimony. We're going to move now to our last bill of the day. And that is the one with lots and lots of witnesses, House Bill 32. We are, wow, okay. So Delegate Jazz Lewis's bill, House Bill 32. Delegate Lewis, do you have a preference as to the first 5 people who you'd like to speak with you?
I do. One moment, Mr. Chair. I just had this up.
There are people who are signed up favorably. There are people who signed up favorable with amendments. Well, I will take the favorable with amendments totally separately, and then the unfavorables, of course, separate from them. What I could do is I could just go down the page and maybe that's the easiest way to do it at this point. It doesn't appear that there are that many people. So let's just do that. It's probably easier on staff too. And we do like to make things easier on Dylan once in a while. Don't record that. All right, so Jazz Lewis will speak for 3 minutes, and Rajani Goodla Valetti for 2, Maris Leon for 2 minutes, Olivia Noggle for 2 minutes, Stanford Frazier for 2 minutes, and then Karen O'Keefe for 2 minutes, and then we'll go to the next panel. All right, so for 3 minutes, Delegate Jazz Lewis on House Bill 32, please.
Thank you, Mr. Chair. Thank you, committee, for your time and attention to this matter. I'm here in support of House Bill 32. This bill ends Maryland's failed drug policy on cannabis prohibition and replaces it with a system to tax and regulate cannabis for adults 21 and older. HB 32 takes marijuana production and sales off the streets and ensures regulated, labeled, and lab-tested products while creating thousands of new good jobs, small businesses, and hundreds of millions of dollars in annual tax revenue to serve the community. Over the summer, I convened an informal work group composed of members of the Legislative Black Caucus to craft legislation rooted in racial justice. HB 32 is the result. There are 3 primary components of equity in the bill. The first is criminal justice reform. Any cannabis legalization bill is meaningless if it does not address record expungement and release of individuals arrested and incarcerated for cannabis-related charges. Despite being decriminalized since 2014, Black people still made up 96% of the marijuana-related arrests made in Baltimore between 2015 and 2017. The The movement towards decriminalization and medical marijuana legalization in Maryland has only made marijuana legal for white consumption, while Black people continue to be punished. House Bill 32 allows for the expungement of records for past conviction and release for people currently incarcerated. The second component is community reinvestment. 63% of the revenue will be directed to reparative justice and to ensuring equity in the industry. This includes 20% of the proceeds for our state's 4 HBCUs, 27% of the funding for a community reinvestment and repair fund to serve communities and individuals impacted by poverty, mass incarceration, and racism via grants to organizations utilizing evidence-proven and evaluated tactics to address these challenges, and another 16% related to equity in the industry, which includes funding for startups, for social equity businesses, technical assistance for applicants, and training for cannabis business workers, including reentry citizens. Lastly is inclusion in the industry. We must ensure those most hurt by cannabis prohibition benefit from the new legal industry. In addition to the funding for inclusion, HB 32 includes a head start for social equity applicants and exclusive access to delivery and transportation licenses. Our bill allows for existing medical businesses to move over into the legal market first on the condition that they pay a significant fee to start up the Social Equity Startup Fund. The Social Equity Fund will provide our social equity businesses with a source of much needed capital, one of the significant barriers to success that we've seen across the country. One of the things we noticed in the medical program is that we needed an advocate for small businesses to ensure they are getting the appropriate support. The bill creates an Office of Social Equity to promote diversity and inclusion in the industry and to foster reparative justice. I cannot understate the importance of having an independent advocate for our smallest businesses to ensure diversity in the industry. The Office of Social Equity will also establish advisory councils in each jurisdiction to advise the office on the needs of that jurisdiction's disproportionately impacted communities. In late fall, I learned that Senator Feldman was introducing his own bill and began negotiations with the shared goal of creating a unity bill. Amendments reflect those negotiations and input from some key stakeholders. I've distributed a handout detailing them, but here are the top line changes. One is tax rate. My bill comes in at 29%. It lowers it to 18%. I'll flag for my colleagues just for a question that will come, and I'll wrap this up, Chair, is that the Virginia bill is at 30% right now. We lower licensing as well from 200 to 100. We increased the possession limit to 4 ounces to mirror the medical program, and we add some labor peace language. The main difference is that our bill has a limited amount of micro cultivators, because that's something that's critically important to the independent dispensaries in order to survive competing with the vertically aligned businesses. I'll end there. I think this is the year that we are talking about equity, and now is the time for us to address this bill. I urge a favorable vote on House Bill 32.
Thank you very much. The remaining will be on for 2 minutes, please. 2 minutes. All right, we'll start with Rajani Goodlavaletti, please.
Hello. Thank you for your time, Chair Clippinger and committee members. I am Rajani Goodlavaletti, an executive leader with Baltimore Harm Reduction Coalition. I am no stranger to this honorable committee at this point. My colleagues and I have testified before you all a number of times now this session, advocating for legislation that would advance the health, dignity, and safety of people targeted by the drug war. And often that involves legislation that directly addresses opioid use and overdose. But our vision for a healthier world requires a model of cannabis legalization that includes strategies for repair from the impacts of the drug war in communities of color. And so that is why Baltimore Harm Reduction Coalition supports HB 32. In order to end the overdose epidemic, we must end the continuously raging war on drugs. Cannabis legalization would actually reduce the fear and isolation in communities devastated by the drug war, specifically Black, Brown, and poor communities. Cannabis legalization would enable those community members using other types of drugs to actually reach out to health and social services, such as those services we provide at BHRC. We have seen this time and again when people feel that they will not be targeted or harassed for what they have or don't have on them, they're actually more inclined to come out of isolation, increasing their risk of increasing their ability to access healthy services. So we support the legalization efforts proposed in HB 32 because it details steps towards repair from the violent drug war, including a cannabis regulation fund that would support voluntary substance use treatment. Marylanders deserve a cadre of options for addressing their needs, especially options that center autonomy and dignity, which is why we love the word voluntary in there. So we ask that the House Judiciary Committee give HB 32 a favorable report. Thank you so much.
Mr. Chair, if I may, I found the list for the order of the other panelists. Thank you, Rajani, for that. I would very much like if we could have Olivia Noggle, then Detective Debbie Ramsey, Hope Wiseman. I messaged.
Okay, hang on.
There we go.
So
I just messaged this to Dylan too.
Debbie Ramsey, and then who else?
Olivia Noggle, Debbie Ramsey, the detective from Baltimore, Hope Wiseman, who's an operator, Mike Wilson with UFCW, and Ben Jealous.
All right, so here's what we're going to do. That's fine. We'll hear from Ms. Noggle, Debbie Ramsey, Ben Jealous, Hope Wiseman, Mike Wilson. The other people who I listed before move to the next panel, and we'll just do it. So hopefully this doesn't create enormous chaos for staff, but hopefully we'll plow through it.
Thank you.
Noggle is on the line. Let's go ahead with that. Olivia Noggle.
Thank you, Mr. Chairman and members of the committee. My name is Olivia Noggle, and I'm a legislative analyst at the Marijuana Policy Project, or MPP. MPP has been working to reform cannabis policy in the United States for 25 years now, and we've played a leading role in most of the major cannabis policy reforms since the year 2000. I'm here today in strong support of HB 32, and I want to thank Delegate Lewis for his tremendous leadership on this legislation. This comprehensive cannabis legalization bill not only would legalize personal possession of cannabis for adults and expunge past cannabis convictions, but the bill also provides robust social equity provisions to ensure business ownership and participation in the legal industry by communities who have been disproportionately impacted by prohibition. And it also reinvests a portion of that tax revenue to those communities. So passing HB 32 this session would save thousands of Marylanders, disproportionately Black Marylanders, from arrest, criminal convictions for simple cannabis possession. It would also create a new source of revenue and jobs for the state, and begin to repair the decades of harm that cannabis prohibition has caused. There are now 15 states that have ended cannabis prohibition and legalized cannabis for adult use, including red states like Montana and South Dakota. It's also worth mentioning that the Virginia House and Senate passed legalization bills on February 5th earlier this month, which are expected to head to a conference committee to harmonize those two bills, and the governor there is supportive. So Maryland should follow suit by passing HB 32 this session. I think it's a cannabis policy that Maryland could really be proud of and be a leader to other states. So thank you so much for your time, and I respectfully urge a favorable report of HB 32.
Debbie Ramsey. Ms. Ramsey on the line?
Here is a participant here. Maybe she's having some trouble. I guess we keep going. Mr. Chair.
Jealous on?
Mr. Chair, I see her on my screen. I don't know if she's we can't hear you, Ms. Ramsey. It shows you're unmuted, but for some reason we can't see you. Hear you.
You may have to jump off and jump back on again. All right, we'll give her the chance to do just that. I think Ben Jealous is on the line.
Yes, Chairman Clevenger, it's good to see you, sir. How are you?
Good to see you. Great. 2 minutes, please.
All right. The tax revenue from legalizing cannabis isn't only going to help our economy recover from losses due to the pandemic, but the truth of the matter is that done right, this legislation is going to save lives. People of color are more likely to be locked up for cannabis and are more likely to experience police brutality in that process. These two issues are intricately linked, and legalizing cannabis is a step in the right direction toward ending the failed war on drugs. what I would also just like to say is that it's just rare that you all have an opportunity to create an industry to right, that, and in the process, right past wrongs and create a more inclusive economy. And Delegate Lewis's bill really stands out amongst, frankly, all the bills that have been introduced in this country in its thoroughness in attempting to really hit all of those. I know that there are some who are pushing forward bills that are more conservative, frankly, more pro-industry in nature. That would be the wrong way to go. We really need to move in a way that is as inclusive as possible, as forward-thinking as possible, and does as much to right past wrongs and to create a more inclusive state, even as we open up this industry. So I would urge support of this bill. Thank you for your time.
Thank you. Go to Hope Wiseman.
Good afternoon, Mr. Chair, Madam Vice Chair, and members of the committee. My name is Hope Wiseman. I'm the founder and CEO of Marion, Maine, one of the only Black-owned cannabis companies in the state. I want to first recognize Delegate Lewis for sponsoring this bill that seeks not only to legalize cannabis in Maryland, but also establishes criminal justice reforms, inclusion, and equity in the process. Marion, Maine strongly supports House Bill 32 with amendments. As a member of the Maryland Medical Dispensary Association, I want to call attention to the fee structure that's been proposed for current medical licenses to participate in the adult use program. As it's written today, cultivators and dispensaries have the same fee requirements, although cultivators make upwards of 10 to 20 times the amount of revenue as a dispensary. Additionally, dispensaries have the lowest margins of the supply chain, as the wholesale cost makes up over 50% of a dispensary's typical revenue. Lastly, 280E restrictions put dispensaries at an even bigger disadvantage, as we cannot write off any of our typical business expenses, leaving our tax liability very high and our profits at the end of the year sometimes non-existent. As it stands, dispensaries would pay at least two $100,000 fees within 1 year, which is well over any type of profits that your typical unaffiliated dispensary can afford. This would leave smaller shops like mine in a place where we would be unable to participate in the new adult use market. Additionally, there are some current licensees like myself that would also qualify as social equity participants, and consideration should be made there as well. We propose that the fee to be paid by each type of licensee should mimic the medical market fees, growers paying the most, then processors, and then dispensaries, as this is based on the amount of revenue that each type of licensee generally makes. For these reasons and more detailed in my written testimony, Marion, Maine requests a favorable report with the sponsors' amendments. Thank you.
Thank you very much. Is Debbie Ramsey on now?
Yes, hi, can you hear me?
Yes, please, for 2
Thank you.
minutes.
Thank you very much. Good afternoon, members of the committee. I'm here to testify in support of HB 32 today. Having spent my career with the Baltimore Police Department, I do believe I do have a responsibility to discuss the public safety impacts on the legalization and control of marijuana. In addition to my public safety career, I'm also the speaker for the Law Enforcement Action Partnership. It's a nonprofit group of police, prosecutors, judges, and other criminal justice professionals. As a detective in the Criminal Investigation Division, Drug Enforcement Section, I was dismayed to see scarce police resources spent on marijuana arrests. We need our police to focus on the greatest threats to our public safety, crimes against persons and crimes against property. Every officer knows that an arrest does not stop marijuana trade. Instead, it creates a job opening with the opportunity to make money. And furthermore, my experience has been that it has been like greater than 50% uses by whites and less than 50% uses by blacks. However, black arrests are 3 times greater than whites. In my estimation, that lets me know that marijuana legalization is already legal in the white community and it's not legal in the black community. So there is an unfairness and a lack of equity when it comes to arrests for the same type of crime. So I'm here to support House Bill 32 based upon my direct and physical experience. Thank you.
Thank you. All right, Michael Wilson, please, for 2 minutes.
Thank you. Good afternoon, Chair Clevenger and members of the committees. My name is Mike Wilson. I'm here today on behalf of the members of the United Food and Commercial Workers Union, Local 400. We represent over 10,000 members in Maryland working on the front lines of the ongoing pandemic in grocery, retail, food distribution, law enforcement, and healthcare. Nationally, UFCW represents over 1.3 million hardworking men and women who work in highly regulated industries, including the emerging legal cannabis industry. Our cannabis members can be found across multiple states in growing and cultivating facilities, manufacturing and processing facilities, and in laboratories and dispensaries, including right here in Maryland and the District of Columbia. Wherever cannabis is legalized, the UFCW is committed to building family-sustaining jobs and a strong, diverse, and skilled workforce. UFCW Local 400 supports HB 32 with the addition of the labor peace agreement language as proposed by Delegate Lewis, as well as the other amendments. Labor peace agreements protect businesses, workers, and consumers, and are an effective regulatory tool as Maryland has seen in other industries. Appropriately, there's been a lot of focus in crafting this legislation on how to ensure there are equitable opportunities for ownership within this new industry. We fully support the creation of an adult use cannabis industry that will do everything possible to make sure that communities, most often Black and Brown communities that have been negatively impacted by uneven enforcement of existing drug laws, have real opportunities to fully participate on an ownership level. An industry that quickly consolidates into the hands of a privileged few is not an industry that will work for Marylanders. We support the social equity language in this bill. While ownership equity is important, it is equally essential that workers in this new industry are treated equitably and have a voice as the industry continues to grow. For too long, communities of color have suffered as a result of top-down policymaking that is disconnected from experiences. This is especially true for communities that have experienced extreme sentencing and racial profiling as a result of the criminalization of cannabis. To truly end cannabis prohibition equitably, Maryland must take steps to address the harms of these decades of over-policing and incarceration of people of color that resulted from cannabis criminalization. The political will and financial resources mobilized in the war on drugs to put people in jail must be matched with equal resources to create an equitable new industry. Unions and frontline cannabis workers can be an important partners in equitable hiring, and worker organizations can be important institutions for establishing hiring centers and training programs that ensure diverse, skilled, and long-tenured workforces. But first, we must decouple the new industry from an unjust criminal justice system and ensure that workers can organize without interference. Labor peace agreements can help address the
Mr. Wilson, if you would please wrap up your testimony.
Yep. Access to representation helps ensure that a broad range of workers can benefit from the industry. We fully support HB 32 with the sponsors' amendments. Thank you.
Thank you very much. Questions for this panel? Delegate Griffith.
Thank you, Mr. Chair. And thank you, Delegate Lewis, for bringing this bill forward. And my questions are really for anybody on the panel. And I have two questions, and they're both covering very different areas of the bill. The first piece is about legalization of edibles. And I went through the bill and I may have missed it, so I apologize for that. You know, a lot of people were looking at what's happened in Colorado with legalization. And there were some incidents early on, and they still go on right now with kids getting a hold of edibles. And to give an example, you know, some teenagers got a hold of a candy bar, kind of like a Hershey bar. But the difference was each block of the candy bar was a serving of THC. And these kids ate the whole thing in one serving and had a very dangerous effect. Additionally, there's laws in Colorado that are very strict addressing packaging for edibles, marketing for edibles, trying to do everything they can to prevent this from getting in the hands of kids, because, you know, my 6-year-old would see an edible candy bar, wouldn't know the difference, and would go to town. So what do we have in place, or are we even allowing edibles to be legalized in this bill, at least initially?
Thank you for your question. I'll allow someone on the panel to follow up. But first, I would say that from the surveys that have been done, the most comprehensive surveys in both Colorado and Washington State, is that once regulation has come aboard, you've seen moderate decreases in teen and children use of cannabis composed to the illicit market, right? So I want to first say that's a good thing. The second thing is that, yeah, the rules would be comparable to that of alcohol, where children shouldn't have access to it, right? Through appropriate product testing, you can determine the strength and potency of the product. There's appropriate labeling so people know that. And with it only being a product that's allowed for folks 21 and older, you'd be in trouble if you gave access to your child. But what we've seen is actually that, young folks have gotten less access as we've disrupted the illicit market, which I think we both could agree on.
And just one follow-up. So I'm reading a study here by the BC Medical Journal, where it said that the hospitalization rate from unintentional pediatric exposures to cannabis was almost double in 2 years after legalization when compared to 2 years before legalization. So I would just like that to be considered very seriously in this legislation. We got to make sure we're not having unintended consequences on that. And then the other question, again, is very, very different, is related to the DUI or DWI with marijuana. And I say that because even in Harford County, I'm walking down the street and I'll have a car blow past me, and no pun intended. And, there's a very strong odor of marijuana being from the vehicle. So if this becomes legal, there's the opportunity for that to grow as well. Also, no pun intended. So what, have you considered this? What remedies do we have in place to try to curb this?
So first thing I would state is that people are currently driving impaired, which is a shame. And I agree with you that we want to address that and get, address impaired driving. I've had friends who died from getting hit by folks who were drunk driving. And one of the earlier bills I had in the legislature, I worked with Chair Atterbury on to strengthen our drunk driving laws. I would say that the current process would be the same that we currently do. We, if someone gets pulled over because they think they are an impaired driver, and Detective Ramsey can speak to this, a drug recognition expert would come to the scene, right, to determine some type of field sobriety test to see if you have your faculties or not. That's what we currently do. It would be the same for this.
Yes, if I may, I would like to comment on the candy component that you spoke about. I'm old enough to remember that there were candy that looked like cigarettes, and the public had an outcry that sent a very negative message, health message to our children, and that candy company stopped doing that. If there's a candy company, I'm not gonna call any name, but the type of candy that you make reference to, well, if they are manufacturing this, or if someone is compromising that candy, then I think the focus needs to be on that.
Well, not that, and thank you for bringing that up, and I appreciate your comment. Not that company is doing it, but there are companies out there that are producing edible versions of marijuana and THC that do resemble these products, and that's the concern.
Yeah. Well, if I were the CEO of let's say a famous chocolate company in Pennsylvania, and someone was probably like using my product to resemble my product, I would, as a CEO person protecting the brand, would want to take some type of action along with the community and combine efforts to make sure that does not happen, because we do need to protect the children. So I don't think we're in a vacuum, but everything falls on you all's shoulders as elected officials. If something like that will happen, I would like to think we as a community would join arms and make sure that cease and desist.
Thank you very much. I appreciate that.
Vice Chair.
Thank you, Mr. Chair, and good to see you, Delegate Lewis. I have 3 questions, Mr. Chair. My first one is directed at Ms. Noggle, and if you could tell the committee since you've worked on this issue across the country, what has the impact been on teens in terms of legalization and teen use?
Yeah, absolutely. Thank you for that question. As Delegate Lewis mentioned briefly, the claim that legalizing cannabis will lead to an increase in teen use is simply not, borne out in the data. Colorado and Washington have both conducted large-scale surveys with thousands of high school students since both states have legalized cannabis in 2012. And those results have actually shown modest decreases in rates of youth cannabis use. And I cite that in my written testimony, just so folks are aware as well. But also I'd like to make the point that, prohibition has done nothing to stop kids from accessing cannabis. And this is because, unlike licensed businesses, drug dealers aren't checking IDs. So this policy here would regulate cannabis, and the cannabis market would require businesses to check IDs for proof of age. And I think regulating cannabis really sends the message to youth that marijuana is for adults and for adult use, to use responsibly.
Thank you. And Mr. Chair, if I could just ask my other, thank you. So Delegate Lewis, I don't know if you want to answer these or point, my questions in the right direction. So my first question is related, do you think there would be any impact on, if Maryland legalizes this, then it's not legal federally. So we're in a situation where we have federal roads, we have people that I think we have the highest concentration of folks that have federal jobs, particularly for minorities. And so what impact or what's the correlation, because this has been a concern of mine, with people getting their clearances and getting jobs and then just getting stopped on the parkway or something. And then my last question, and this is a concern of mine too when we've heard similar legalization, is, and we've seen this bear out, that the medical was a complete failure for Black people. Okay, and I have a huge problem with that, as the Legislative Black Caucus does, and as you do, which I thank you for your focus on this. I personally would not support anything that did not have some protections for Black people being able to participate in this industry, which is why I'm happy to see Ms. Wiseman here today, and she's a female, so glad. So I haven't read the legislation in detail yet, but I do see, disproportionately impacted area and disadvantaged equity applicants in your social equity provisions. So how, if you could just briefly, how does that play? Like, would there be a certain amount of licenses or?
So first, I'm gonna answer your first question, and I'm gonna read this to be clear. So the DOJ has made it exceptionally clear that states can regulate the cultivation and sale of cannabis for adult use. In an August 2013 memo, then Deputy Attorney General James Cole said the DOJ will refrain from interfering as long as states are establishing and enforcing regulations that adequately address specific federal interests, such as restricting cannabis sales to minors and preventing interstate trafficking, which our bill does. Okay, so that's the first thing. We don't have to worry about the FBI coming in and messing stuff up, right? Because if we were, they would already done it for the medical program. We are adhering to the law. That's the first part. On your second question, which I really appreciate, is like, how are we making sure that we take care of the communities that's been disproportionately impacted from a social equity standpoint? The first thing is, so a number of the medical businesses can move over. They have to pay a pretty significant fee, as I referenced and Hope referenced as well, to establish a startup fund, right? That will be exclusively for minority businesses. And what we mean by social equity applicant, we sent a question to the AG to just make sure the language we have is constitutional. We're waiting for that to come back right now. But there's three included groups in the definition. One is people who are formerly incarcerated and their immediate relatives. So if you are the child or spouse of someone who's formerly incarcerated for a cannabis-related charge, you can be a social equity applicant. If you live in a disproportionately impacted community, and that is data proven by over-policing and mass incarceration, you can also be included. The third one, which is the one in contention that we've been working with the Black Caucus on, is also if you are a racial minority within the state. Okay, because the first two.
I was about to say, not to cut you off.
Yeah.
What if you're just Black and you live in the suburbs?
I know. Technically, if you've grown up in the suburbs, and you're Black, you've definitely still dealt with the challenges of the criminal justice system, not to the same extent as if you lived in a disproportionately impacted community, or if your parent was locked up for incarceration. So, we were trying to include all of that. That third part, we know about the strict scrutiny tests that we always have to have with disparity studies for set-asides and things like that. So we sent that specific one to the AG, and we're waiting for their guidance back, but it's in the bill. To be clear, it's in the bill. We set aside some of the ancillary businesses exclusively for social equity. So people who are providing security, transportation, delivery services can only be social equity. We have an unlimited number of micro cultivators, which we think multiple our social equity folks would be there. And essentially that means, look, a lot of minorities and people from low-income communities aren't going to have the money to buy these 50,000 square foot greenhouses to get into the industry, okay? But they may be able to convert their basement into a little greenhouse and set up a partnership with a dispensary to provide some type of product, right? Those create more pathways into the industry that we are also allowing. So there's a lot there. I mean, I can go all day on this. We established a Office of Social Equity too, to be like an advocate to make sure as the regulations and things are being promulgated, there's someone in the room fighting for our folks, and not just kind of like what we saw in the medical program, where it seemed like, to be honest, a lot of the vertically aligned, big corporate venture-backed folks had a heavy say in the writing of the regulations for the medical program. And that wasn't fair to independent stores like Hope's, right? And that's who we're fighting for.
Thank you. Thank you, Mr. Chair.
We'll go now to Delegate Ron Watson, followed by Delegates Cox, Grammer, and Lopez. Delegate Watson.
Thank you, Mr. Chairman. Good to see you. Delegate Lewis, I received a lot of phone calls about this bill. And much like the Vice Chair said, publicly, that I would not support anything unless I saw the clear social equity impact and how this helps to build generational wealth, particularly in Black communities. I'm glad to say I see that. There was one thing that was mentioned, righting past wrongs, right? And it looks like you have, dismissal of pending charges applicable to cultivation use, but why not sale? And if you have raised the personal amount to 4 ounces, that's the equivalent of 50 to 100 joints. Why wouldn't the person who was on the street selling this in a nonviolent manner also be covered under this? It seems like everybody is taken care of except the sales guy or gal.
Yeah, so you can actually, through the bill, you can petition for expungement through it. It's just not automatic. We're actually working with the judiciary amendments because, as we've found out through working through this, after you are arrested, right, and they book you and they put your information in the system, they don't track the amount of possession you had from that point on, right? So in their records, it is just what they have you for simple possession, for possession with intent to distribute, things like that. So, I would gladly, that is up to the will of the committee. I would gladly clear it all. I imagine there may be some difference of opinion as to, at what level someone moves from being a corner boy to something a little bit more, right? But I would gladly help them all, particularly if we're going to make this industry legal. And let's just close the chapter on this and move forward, right? I think that's the best way to disrupt the illicit market, is those folks are free to go and do something else, and why wouldn't they? I agree.
No, and I agree with you. I would just ask you to take a look at the language to make sure it's inclusive of the person who's selling it as well, if it's a small amount within this limitation. My other question is, and we actually discussed this last year in this committee, there is right now no analogous test like field sobriety test where you say 0.0 whatever constitutes your inability to legally operate a motor vehicle, right? We can do we can figure out if somebody's on drugs, but we can't tell how much drugs they've used. And it becomes very, very subjective as to how impaired a person is. And there are many people in my community who are concerned that this wouldn't just give another reason for law officers to pull over Black and brown folks and to charge them with a crime without having that clear standard. And I heard somebody mention, I think it might have been Ms. Ramsey, but can somebody just comment again on what that field test would look like? Because if you recall my concerns last year, where we seek to make this legal, and each industry is going to have to put their own rules in place. You're not going to have a doctor who goes to lunch, smokes a joint, and then does a robotic surgery, right? You're not going to have somebody that operates heavy machinery take a lunch break and then come back and deal with a forklift. There are going to be those kinds of things in place, and certainly those people who work in some federal government aspects are going to have to follow different rules and regulations. And so in my mind, the ability to be able to test and come up with some kind of standard, and I haven't researched, all the states that have cannabis legalized, but is there something that we can look to now to start putting in place that goes in tandem with this bill to make sure everybody's protected?
I'll say something real quick and then I'll defer to Detective Ramsey on the way the sobriety test functions. But there's some new devices that are being tested right now that would determine the more recent use of cannabis through blood draws that could be approved shortly. But it's more recent. I'll also state that a portion of the revenues from the bill goes to training additional drug recognition experts on how to detect all forms of impaired driving, not just cannabis. The other thing is we don't actually change, no legalization bill in the country changes employers' ability to prohibit, use while folks are at work. We don't touch that at all. I don't think we would want to. No one wants, educators, truck drivers, anyone showing up to work impaired, whether that's alcohol or anything else. It's, I agree with you. That's just a safety, common sense thing, and our bill leaves in those protections. Detective Ramsey?
Yes, I would just like to add that today's technologies, there are many more modern ways of determining the chemical amounts in a person, as opposed to like your typical field sobriety test, where the officer is pretty much is subjective and not so much being objective. Another thing, it really supports what we said earlier, that Blacks are 3 times more apt to be arrested than whites. So we have to look at profiling, because believe you me, if we just looked at that data, it would indicate that whites are going about their merry way, going to the operating room, going to their job or whatever, and they are chemical free, and that's not the case. So until we address the profiling reality that Blacks and Browns are being stopped more, then it's just like compounding the problem. If there are more devices and more methods of stopping someone to determine the chemical amount that they may have that may be impairing them, we still are focusing on the Black and brown communities. So as a detective, that's where I'm coming from. I would prefer to see us get to the point in society where things are not so lopsided, and until we address the police department and how police officers are using their judgment when they want to stop someone, they see me and they may be triggered to say, well, she's probably doesn't have a driver's license or may be impaired. So I would like to address those things before we get into other penalties and compounding more ways of arresting the Black and brown community. And I just don't see how this should be something that should be stopped, because we haven't figured that part out. We haven't figured out the real injustice, and now we want to compound the problem by adding on more. So now when a Black and brown person is stopped, now, yeah, we do have a new technological way of doing the field sobriety test, but we're still targeting the Black and brown communities.
Thanks, Detective Ramsey. And just in closing, if you could consider, Jazz, putting some kind of metric in place, because if this starts off, we would really like, we're going to have to revisit this sometime. And just to make sure that it's fair, it's balanced, and it's really serving its purpose. And I would love if we had some kind of metrics in place that we could look at over time to make sure we were serving our communities the way that this social equity piece was built. All right, so thank you very much.
No problem, will do.
All right, we'll go now to Delegates Cox, Grammer, and Lopez. Delegate Cox.
Thank you, Mr. Chairman, and Delegate Lewis, it's good to see you again back in your former committee. We send you regards. This is a big bill, and I know you know that, and I know you're working on it. It's apparently been amended or something. I just was emailed the updated version, so if I say a page number wrong, it's because I'm looking at the new one that just came in the email. But real quickly, two questions that people sent to me that they were curious about. First of all, in terms of the bigger, broader question, the Professor Aria, I think, had testimony here from the University of Maryland Public Health Policy, indicating that she apparently and the university did a recent study of 1,200 students, and that there's significant concern about in their science review of complete decriminalization to increase some of those poor behaviors or results that they determined in their study. That would be one. But the secondary question is, we do have a process right now, as everyone is familiar with, for the dispensaries that exist in the state. And they're concerned about the removal of delivery service because they've invested millions of dollars in their delivery vehicles. And now this is being potentially removed. And so I don't know how that will work in terms of allowing delivery only for, maybe you could speak to that, only for the, I think on page 51, it says the social equity applicants would then only be the ones open or able to deliver under this legislation. So how would that work for somebody who already has a license and has invested millions into that delivery service?
Yeah, so I think for the folks who are currently in the medical program, it wouldn't change anything at all. This would only be for the adult use and ensuring that in industry in Maryland, right? Like, let's be clear, 30% of Maryland is Black, just half of the state is minority writ large. And we had very limited diversity in the industry. So, if we're going to be serious about addressing wealth inequality, income inequality, we need to put our money where our mouth is. And I think this is one of the places where we can do it. It doesn't disrupt the relationships people have at all currently in the medical program. But it's saying for the adult use, we're going to set this aside for social equity to make sure that we address some of these disparities. I'd love to talk to them about that. But look, if they invested in a fleet or what have you, they invested it for the business they're currently in, which is the medical program. I don't think, anyone is entitled to anything in a legal program that we don't have yet, right? We're trying to create as fair an economy as possible. I also just found out, I believe, like the Maryland Department of Health is coming out in support of my bill. So, I'd love to talk to the, I guess the school of health that you referenced, but I just, got a message that our Department of Health for the state is in support of what we're trying to do. I'm not here suggesting that cannabis use is, is healthy, right? That's not my argument here. Any type of product, whether that's alcohol, tobacco, you name it, is not going to, make you better, right, than just sobriety. I am saying, though, that the collateral consequences of prohibition is much worse. Okay, we have an illicit market right now that teenagers and other people are able to access. And that entire experience, which is illegal, causes violence and other things. And I think we can agree that we don't want that, right? So this bill is a down payment on us getting to where we should be.
Thank you, Delegate.
Delegate Grammer, then Lopez, then Williams. Members of the committee, I'm going to be stepping away here. Right now, I need to attend to another matter really quickly. So I'm going to be handing this over to the vice chair. So Delegate Grammer was the next.
Thank you, Mr. Chair, and thank you, Delegate Lewis. It's good to see you. So my question is about the community impact. If this bill were passed, if we were to hypothetically legalize, several years ago, we removed the criminal penalty for, I believe it was consumption of alcohol in public. And what locally we started to realize is that when we have an issue of someone who's really creating a bad situation by drinking publicly, drinking alcohol publicly, is that we were struggling to deal with that now because it was really tough to deal with because there's no crime and police can only do so much in that circumstance. And you know, people talk about the criminal justice parts of the bill, of the legalization, or the industry considerations, or the public safety considerations. But what I think in a lot of cases people don't think about is what's going to happen in communities. And I think for most people that'll probably be the part of this that impacts them most. Like what's going to happen when someone's smoking in the community, someone's smoking on the school playground. What about when you're smoking in a row home and now your house smells like marijuana? So I wanted to ask you what other states do as far as that, like local land use kind of consideration, allowing localities to adopt penalties for use in specific locations, parks, things like that, school grounds. What do other states do to handle that? And what does your bill do to handle that?
So our bill doesn't touch on any of the zoning components of which is purely in the jurisdiction of localities. I would say, it makes cannabis use comparable to other things. Public consumption is, in the bill, public consumption is a civil fine of $50, I believe, in the bill. So we're not saying that people should be using publicly, even in the bill. All right, there's still a consequence for that. You can report them. We don't suggest people doing that, but you can. Instead of incarceration, we are redirecting people really to like community uplift. So one of the things that I'm pretty proud of in the bill is that as an alternative to paying a fine, which we know of the collateral consequences of giving people fines, particularly if they can't pay it, right? And what happens with debtor prisons, et cetera. We require community service in those communities. The judiciary has let us know that not every jurisdiction has a community service program across the state. So one of the amendments that we brought up, I just didn't have enough time in my 3 minutes to go into this, but one of the amendments we bring is that through taxing the product, we have this community repair fund, and a significant amount of money will go to every jurisdiction that has disproportionately impacted communities, okay? For the jurisdictions that don't have like a community service program, the people who violate the rule will essentially get connected to the Office of Social Equity to do community services to one of the grantees there to make sure they're still doing it. But it's not incarceration, it's service and uplift to the community.
What do they do in do you have any information that you could share about situations where, like a strict prohibition situation, like school grounds, school parks, the baseball diamond at your local elementary school? How do other states handle that?
I think they leave some of that up to zoning control. I will pivot to allow Olivia or some of the others who've worked in other states to speak up, but I believe mostly that has been left to localities to decide, similar to what we did with our medical program, right? To decide. But Olivia?
Yeah, I mean, Karen might be able to answer a little bit better. She's going to be testifying later. But, you know, I think that would remain illegal. I don't think anyone's going to allow that. And Delegate Lewis did touch on here that, you know, most other states have handled this similarly to alcohol, that, you know, smoking cannabis in public is going to be treated just like alcohol. So.
Let me get technical on you, Olivia. When we say like it remains illegal, technically it's not illegal, and that therein lies the catch-22. And that's, you know, it's a very technical thing, but it's a very important thing, because if suddenly you know, we have situations where it'll be a local liquor store that really presses the lines with serving inebriated people or serving youth, and we have issues with illicit drug distribution, you know, and we just can't, now we can't move people, staying in the spirit of not arresting people. In Baltimore County, for the most part, at least in my district, they don't go to arresting people first. But there are situations where they say, like, look, dude, you cannot be smashed drunk on this corner. And this is the thing that's going to come to the forefront. And it won't be every day, but it's going to be, you know, we're going to have to deal with these situations. And I remember as a child being at the local ball field, and, you know, mom had to get us the hell out of Dodge because she wasn't comfortable with a bunch of guys smoking pot on the ball field. And if it's legal, you know, where are kids going to go? They're going to go to the ball field. So I just like to hear more about
Delegate, you're talking about public intoxication, right?
Which is public consumption.
Public consumption. Yeah. But this would be comparable to our rules on public intoxication, you know, which is
a civil fine. A civil fine, right?
Yeah. I mean, I do think there's some differences. Like typically, if, you know, for some of the public intoxication stuff, you know, Delegate Fisher and I have separate bills dealing with some of these alcohol issues, specifically in Prince George's. But, you know, some of it deals with addiction and other things that's going on with those individuals, right? And I did want to flag, a lot of people's consumption, even adult use program, is purely medicinal for their needs. Right. It's anxiety or sleep or other things. So, you know, I think that the challenge we have is, like, we are comparing a market that's currently illegal and illicit now, and how people operate with that now, to how it will be once it's legal. The best way to compare it is the last time we moved from something that was prohibited to legal, which was alcohol, right? We used to have speakeasies, you know, and people meeting in little shady places back then. And then now, you know, folks, more often than not, they drink in bars, or they drink at home with their friends. Most folks aren't publicly intoxicated like that, right? So, but I'm happy to talk to you more about this.
Yeah, let's talk about this. I don't make any decisions about bills this big, but I think this is something we can keep. If the bill does move, we can keep it in the spirit of the bill, while really allowing local jurisdictions to handle problems that are really legitimate. But I appreciate the time.
Okay, so we've got folks with more questions, and we have a lot of more people signed up to testify, folks. Okay, so we're going to go Delegates Lopez, Delegates Williams. I saw Delegate Conway. Do you still have a question? No. Okay. And then Lopez, Williams, and then Delegate Watson. Delegate Lopez.
Thank you, Madam Chair. I'll be snappy about it. We've mentioned, kind of alluded a few times to a community reinvestment fund. Are there any specific numbers you can offer up about revenue that's going to be generated there, just to get a sense of scale?
Sure thing. So the tax projections that we have, and I will state this is based on the amended bill, would be about $200 million would go to the Community Reinvestment Fund, which would then be distributed to the disproportionately impacted communities all across the states. That's every jurisdiction has some area that is disproportionately impacted. 198 million would go to the general fund. 158 million we anticipate going directly to the endowments of our 4 HBCUs to help stand them up. nearly 80 million for our social equity startup fund. And essentially we have a provision that after 4 years, if folks don't need that additional equity, that money too would also move to our community reinvestment fund. There'd be 24 million for training and technical assistance, 55 million for substance abuse prevention and treatment, not just for cannabis abuse, but for all drug abuse across the state, which is near and dear to my heart. 15.8 million on cannabis related research, and another 15.8 million for public education. And I think, we've kind of hinted at teen and children's use before, and we dedicate a significant portion of the revenues to a constantly going program to educate the public, but specifically young people, on the dangers of abusing drugs, cannabis, but also alcohol, tobacco, and other products. And around $8 million would go to training drug recognition experts and other law enforcement on impaired driving. Thank you for your question.
Delegate Williams?
Yes, thank you, Vice Chair. And thank you, Delegate Lewis, for bringing this bill. My questions have to do, I saw in some of the written testimony, some comments and suggestions about the existing medical program and overlap with what you're proposing. I was wondering if you had any thoughts about those suggestions, unifying the regulatory agency for the medical program with this, with the adult use program. And kind of along those same lines, as a second part to prong to my question, with regards to grandfathering in some of the larger facilities that may exceed the tier system that you have currently in your proposed bill that currently exist.
Yes, so I'm open to conversations about blending the two. In most states, what happened was that they had a medical established a adult use, and then within 2 to 3 years, they rolled the medical into the adult use program. So I'm more than open to an idea where we bring them together. The only thing I would state on that, and this isn't really my position, but is position of a number of folks within the Legislative Black Caucus that I've heard, is that the Medical Cannabis Commission, their rollout did not address equity. So I think their concern was that they didn't want an adult use program rolling into the medical, as opposed to medical rolling into something else that may be having a expanded board or changed board, and just a couple of changes. But I've spoken to the staff at the Medical Cannabis Commission. I'm very much open to it. I consider this bill, a caucus bill, a bill of the body. Some points in the bill, not necessarily my arguing points as much as other people too. And I have to, I can't necessarily promise for them. But I do think the best thing for businesses is that we have them all under one situation, so that if you are, let's say, a dual licensee and you're in both the adult use and the medical, you're not worrying about separate regulations to balance. I think that's common sense, and I agree with us putting them under the same umbrella to mitigate that. The other thing about grandfathering in, particularly for the larger ones, if they're medical and want to move over, I think we can. I think I just want to have a little bit of conversation about, impact of, let's say, if you're larger than the largest tier we have, and their influence on shaping the market. Because like I've stated a couple times, I just want to make sure, to Delegate Watson's point and Delegate Atterbury's point, that we have true equity in this business, right? So, if there's, if some operators are just so large that they have an outside say, that's something we should talk about. I'm not saying we would say no, but it's something that we should all know before we vote on something, right? And have ownership over that.
All right, thank you. I do appreciate the equity and exclusion portion of the bill, and definitely agree with the comments about the medical rollout and the flaws that occurred with that. Thank you.
Delegate Watson, and then we'll move on to the next panel.
All right, thank you, Madam Chair. Delegate Lewis, I remember 2 years ago, we challenged the judiciary to upgrade and modernize their system so that they could do automatic expungements. Do you have any reactions at all to the Maryland Judiciary's concern in their testimony about the fiscal impacts to administer the expunge?
I do, and we're talking to them about how we can mitigate that. So right now, you all are well familiar with the unit rule that my district mate, Delegate Barron, had a bill on, to help address. And that's ultimately the issue. All these records are together, and it's very staff intensive to remove them. First, I'd like to say that I think the cost of having the scarlet letter of a criminal conviction on your neck for the rest of your life is more expensive than the cost of having staff go through and manually edit some records. I'll state that, but I am working with the judiciary to mitigate the fiscal note by possibly shielding records, which they can do much more quickly for 1/100th of that cost, right? It's a technological change and the public won't be able to see it. That is an actual expungement. That would be a concession we would be making, but I think it would be shielding from public view. People can still go to the courthouse and look up this information. But for people who are looking for jobs, employers just can't go on case search and find. And that's actually a bill that Delegate Moon had in the past, and we would be adapting that language. I think that's what the judiciary would prefer, and we're talking to them about how we do that most effectively. If we adopted that, I would still keep in the bill the provision of the Office of Public Defender helping folks who want to get expungement, essentially at no cost, just so that, we can get this scarlet letter. The idea would allow people to make, billions of dollars, right? And then people will still have this, for lack of a better word, right, legal noose, okay, holding them back from gainful employment is unacceptable. But I will relent if it can help us move this bill forward. But ultimately, that's the will of the committee.
Okay, thank you. And now we will move on to the next panel. Will Tilburg, Amaris Leon, Stanford Frazier, Karen O'Keefe, and Gordon McAllister. So we will give them a minute to come in and let the first panel get out.
But I will relent if it can help us move this bill.
Yep, so if you are coming in, please make sure you are muted, and also make sure that you don't have the live stream going on the YouTube link. So we will get started. Will Tilburg, and you will have 2 minutes. Everyone will have 2 minutes, but when you're ready.
Thank you. Good afternoon, Madam Chair, members of the committee. Will Tilburg here on behalf of the Maryland Medical Cannabis Commission. The commission does not, as the state's regulatory body for the medical program, does not take a position on House Bill 32, but based on our review and conversations with regulators in other jurisdictions, want to share information on best practices, as well as lessons learned over 7 years of regulating the medical program here in Maryland. Based on these experiences, I'd like to highlight 3 areas that are potentially going to hinder the implementation and rollout of this program as currently drafted. Each of these have been previously discussed with the bill sponsor, and we're hopeful that we will continue to have those conversations. First, Maryland here is proposing to be the only state currently in the country to have separately regulated medical and adult use programs. Why have no other states chosen to do that or chosen to move away from that? The answer is because it quite literally doubles the administrative cost to the state. You're having 2 agencies perform substantively identical work, and that has costs. Second, the bill provides for dual licenses. So those that have medical licenses also have adult use. These facilities would be able to dispense medical and adult use cannabis from the same dispensary and would be subject to two separate sets of regulations. And so if there was a disagreement between the adult use and medical regulations, quite literally, the business could not comply with both. For the second piece, there's been some discussion, my second point, there's been some discussion of potential missteps of rolling out of the medical program in the state. The medical program as initially set up was part-time volunteers who did not have cannabis science law policy experience. The proposal under this bill is to give adult use to a commission that has no cannabis science law or policy experience. And so it presents the possibility of delays in drafting regulations and getting the program up and running. The third piece is data collection. What we've heard from partners, colleagues across the country is that data collection in terms of drug driving, youth use, substance use disorders was lacking at the time of legalization. And as a result, there was insufficient data to track the health and safety impacts of legalization and determine what, if any, interventions were appropriate to address those harms. It was discussed earlier that Colorado and Oregon and Washington saw actual decreases in youth use. That was because there was robust surveillance, data collection, and public education in these areas.
Mr. Tilburg, if you could wrap up, I'm
Yep.
sure there'll be questions.
Sure. So that's it for the committee. I'm happy to answer any questions you have.
Thank you. Amaris Leon, you'll have 2 minutes.
Madam Vice Chair, my name is Amaris Leon. I serve as a criminal justice reform strategist for the Working Families Party, and on behalf of WFP, I testify in favor of HB 32. As a party, we fight for racial equity, ending mass incarceration, and the creation of systems that uplift marginalized communities. HB 32 would help us put on us a pathway to achieving all of that, from full legalization to creating a path for entrepreneurs of color to making people harmed by the war on drugs whole again. HB 32 mandates the creation of a community reinvestment fund, which would allocate a portion of its new revenue to necessary programs like housing assistance, violence prevention, and youth development. Additionally, another portion of this revenue would be dispatched to HBCU endowment funds. And as I understand very intimately the significant role that they play in stabilizing families of color and giving them financial stability, two of the most important factors of crime reduction. And lastly, shifting this focus to the criminal justice component of the bill, HB 32 would help us in our goal to end mass incarceration. As a former foster care youth myself, I'd be remiss if I didn't talk about how mass incarceration by war on drugs has disproportionately impacted women and their children. Women have become the fastest growing prison population in the country, and 55% of incarcerated women are mothers to minor children. Studies also show that children of incarcerated mothers in particular are more likely to end up in the system. And I think it comes to no surprise that children in the system are at great risk of youth delinquency and crime due to their unstable nature and society's general lack of concern for them, thus perpetuating a cycle of community instability, poverty, crime, and violence at the hands of the war on drugs, which has historically included cannabis for people of color in particular. So in closing, WFP urges you to vote in favor of HB 32, as its passage would not only economically benefit your state, but as a public health policy would begin the process of rebuilding communities and creating long-term stability. Thank you.
Thank you. Next, Stanford Frazier for 2 minutes.
Thank you, Madam Chair and Madam Vice Chair, I apologize, and members of the Judiciary Committee. I'm here, my name is Stanford Frazier, and I'm here with the Public Defender's Office, and we will support a favorable reading of this bill. A poll conducted in October 2020 found nationally that 68% of Americans support making cannabis use legal for adults. A poll from earlier in 2020 showed that amongst Marylanders, about 57% of Maryland supports legalization versus only 38% that opposed it. We believe government resources should not be wasted arresting and prosecuting cannabis consumers. According to DOJ statistics for 2018, across the nation, approximately 663,000 Americans were arrested for cannabis use offenses, and 92% of those arrests were just for possession. That equated to around about one possession arrest every 48 seconds. The public defender is thankful that the legislation has authorizes our attorneys to do expungements as well as file motions for people that would be currently incarcerated for marijuana convictions. And we know that after decriminalization that our office, we were able to have some expungement clinics and have some success in expunging some of those records. We know that there There was some previous testimony and questions about discrepancy in stops of Black and Brown people. And we think some things that could strengthen the bill actually is that what we found in our research is that in Colorado, when it was legalized, that actually their child protective services were using a parent's legal use of marijuana to actually start parental neglect cases. We believe that should be addressed in this legislation. We also know that under certain legal concepts, that the smell of marijuana may be used as a means to stop and frisk an individual or a warrantless search of a vehicle. And we think language around that issue can be put inside the bill and address some of those previous concerns. But despite that, nonetheless, our office supports this bill and we ask for a favorable reading from the committee.
Thank you. Next, Karen O'Keefe for 2 minutes.
Hello, good afternoon. I'm Karen O'Keefe. I'm an attorney and the Director of State Policies at the Marijuana Policy Project. My colleagues and I had the honor of working with Delegate Lewis and an informal working group from both chambers to help develop HB 32, and we have assisted with the amendments to help harmonize the House and the Senate bills. I wanted to address a few points from others' testimony and to highlight amendments that address input while staying true to the goals of creating an equitable system of regulation with ample funding for community reinvestment. On the issue of startup fees, a few dispensaries have raised concerns about them. We want to balance the need to promote diversity while also being responsive to input. In line with Ms. Wiseman's recommendation, which was excellent, it includes in the amendment a reduction for those social equity startup funds for existing medical providers if the operator would qualify as a social equity applicant or a minority business organization. It also makes modest reductions to the fees for dispensaries and increases the fees for processors. However, there's still a substantial fee for most of the businesses in order to foster the need for inclusion and diversity in the industry and provide startup capital. Next, some growers have urged that the bill cap licenses for new growers. The amendments address concerns by limiting the number of medium and large grow licenses, but it balances the need to avoid a numerical cap on micro grows and instead just stops their issuance if there's ever an oversupply. This makes sure that small growers, small producers of products, and retailers are not at a significant competitive disadvantage when compared to the existing vertically integrated medical growers. It makes sure these small businesses can have a supply. It's also consistent with the recommendations of Virginia's Independent Legislative Research Commission on how to foster equity and small business. Next, some of the dispensaries have recommended fewer retailers. The reprint would reduce retail licenses in 2023 from 200 to 100, which is far, far less than the 500 plus in both Washington and Colorado. It balances their wishes with the need for opportunity for diverse operators and for consumers to have choices and ready access. Thank you, and we urge a favorable report.
Thank you. So that concludes this panel. Committee members, if you have questions, please raise your hand. And there are a lot of people. I'm scrolling through. If I miss you, you can chat me or just text me. So I have so far delegates Cardin, and then we'll go to Fisher and Grammer.
Thank you very much, Madam Chair, or Vice Chair, and members of the committee. I just based on the testimony that just happened, I cannot remember the woman's name. Very, very effective testimony. I just was wondering if the chairman of the Cannabis Commission might be able to provide for us information about what the wholesale price is nationally of cannabis vis-a-vis or versus what the wholesale price is in Maryland, because one of the things I've heard is the issue of supply and demand, and that there's all kinds of issues with the dispensaries and the retail establishment getting their prices. Their prices are getting hammered because of the competition, because there's so many dispensaries, but the wholesale price is way, way, way high because there's so few growers. I'm wondering if you can provide that information or if you can get that for us.
Sure, I'm happy to respond to the committee with wholesale data. What I can say at this time is over the past year, so in 2020 was the first year nationally that wholesale prices increased. This was largely attributed to constraints put on markets in states across the country due to the pandemic. And that is specifically surges in use. We saw a significant increase in the number of patients, as did other states and consumers in states that have adult use. And also some constraints on the production side with loss of employees due to positive testing or having to stay home to take care of kids. So it was somewhat of an outlier across states of an increase in wholesale prices. And it also, for Maryland specifically, about half of the wholesalers in the state actually reduced their prices in 2020, half increased. And the overall cost of wholesale prices did increase. So it was somewhat mixed by wholesaler, but overall it did increase. And that was consistent with across the country.
Thank you. And I did unintentionally leave out Gordon McAllister, so we will give him 2 minutes and then return to questions. So Mr. McAllister, if you could put your video on and then you can go ahead. You have to unmute yourself, sir.
Okay, now do you hear me?
Yes, thank you.
Thank you. And I'll be brief since everything seems like it's been covered in this. I'm testifying on behalf of myself. I'm a resident of Queenstown, Maryland, and on behalf of the Law Enforcement Action Partnership. I've been a trial judge for 28 years. I'm retired. Prior to that, I was a chief public defender. All of that occurred in Oklahoma. My judicial docket was 25% just pure drug cases, 50% if you included all drug-related crimes, which ranged from petty theft to capital murder. The passage of this bill would be a start toward reducing marijuana arrests and would allow police, prosecutors, and courts more time to devote to serious crime. I hope this is a first step towards ultimate legalization. It would also lessen the damage done to fellow citizens who are marijuana users. In fact, the most serious damage done to us not by the drug itself, but by the legal process. We had a saying in Oklahoma about drug use that you can overcome an addiction, but you'll never overcome a conviction. And that's the sad truth with regard to marijuana. As a trial judge under our current criminal system, I often felt that we helped nobody, but in fact, we were intent on shooting the wounded. Since the 70s, we've chanted the motto, "Be tough on crime." We put so many fellow citizens behind bars that if our criminal population were a state, it'd be the 16th most populous state in the Union. Maryland's the 19th most popular. Law enforcement costs have gone from $2 billion a year in 1967 to $137 billion a year in 2018. We need a new philosophy, and this is a step toward that. We need to be smart on crime and not tough on crime. House Bill 32 moves us closer to a smart drug policy, and I thank you for the opportunity to speak.
Thank you. Delegate Fisher, did you still have a question?
I'm going to hold, Madam Chair. Delegate Cardin sort of touched on my question.
Okay, thank you. Delegate Grammer?
Thank you, Madam Chair. Ms. O'Keefe, they passed the hot potato to you, so I wanted to revisit the question. What do other states do? Do you know? Can you tell me what the other states do about the community concerns? I think it will be something that changes, and in localities like Baltimore County, I mean, we're starting to really struggle with this, as it is removing the penalty from alcohol consumption. Can you speak to that at all?
Yeah, I mean, I think it depends on the states. There are 15 states where marijuana is legal now. All of them continue to prohibit public consumption. In most cases, it's a civil penalty. I believe a number of states allow localities to impose their own penalties for public consumption as well. In most or all cases, landlords continue to be able to take action if they have a tenant that smokes cannabis. In this bill in particular, it says landlords can take action against their tenants if they smoke cannabis, or after a warning if they do anything else with cannabis that creates a smell that bothers their neighbors. I don't believe there's any language to prevent action from public intoxication. And in existing Maryland law, there is a statewide penalty for public intoxication. It's under the Alcohol Beverages Code, but it just uses the word intoxication and doesn't specifically say it only applies to alcohol. So I have no reason to think it wouldn't apply to intoxication by cannabis as well. So, it varies by state, but usually it's a fine for public consumption. There has been concern about the idea of continuing to arrest people in public for using cannabis, and we would oppose jailing people for using cannabis in public. There are people that live in subsidized housing that cannot use cannabis in their homes. Certainly it's appropriate to have a penalty, but I think I've seen signs in elevators that say it's a $25 fine to smoke a cigarette in elevators, and we haven't seen an epidemic of that. And certainly smoking cigarettes is far more dangerous secondhand than cannabis. So, states have taken action to penalize it. Another thing is just having a public space where people can go so that they're not in their own home. And this bill would allow localities to create public consumption locations so you can deal with the issue of people wanting to consume cannabis without, sending them out on the streets or have to do it in their home.
Yeah, I'm worried less about the like an apartment environment. I think they kind of handle it now, and it exists now and they deal with it. Same with the business space. I think that's what you're referring to. I creating spaces for people to go. I think that'll happen one day. That's just going to happen naturally. My bigger concern is like at a local business, some kind of toxic situation around a liquor store or something along those lines. Those examples, civil fine enforced by local law enforcement, or they delegate the locality the ability to adopt some kind of penalty. Did I hear that correctly?
Well, if the person's disorderly, obviously cannabis is not linked to aggression the way alcohol is, but if a person's disorderly, there's existing penalties for that disorderly conduct. If they're intoxicated in public, there's penalty for that. If they smoke cannabis in public, there's the $50 fine. You were talking before about somebody smoking on a baseball diamond. Again, I'm very concerned about the implications of criminalizing people, especially young people. But if they're a student, there's all kinds of student penalties that can be imposed, detention, suspension, telling the parents they can take away privileges and ground them. It doesn't have a specific on-school property penalty other than public use, but there are a lot of non-criminal means that can and should be used to address problematic conduct by young people, by both parents and schools, without locking them up, in my opinion.
Okay, thank you.
Mm-hmm.
Okay, seeing no further questions for this panel, we will move on. Thank you very much. So we are going to now call Alfreda Hilton, Christopher Stevenson, Martin Mitchell, Miguel Jones, and Daryl Carrington. And this will be our last panel of favorable. Then we have a panel of favorable with amendments, and then we have unfavorables, folks. So we will just let them come in. Panel of favorable, then we have a panel of favorable with amendments. If you're coming in, please mute yourself and turn off the live stream that you might be listening to. Okay, we will begin. Alfreda Hilton, you can begin and you have 2 minutes.
Thank you, Madam Chair. I appreciate the opportunity to welcome my testimony and to the committee panel. My name is Alfreda Hilton. I am a member of Progressive Maryland. I'm also African-American mother that has 4 sons. 2 of my older sons were driven from their jobs and families and pushed into the federal prison systems for possession with intent to distribute, and both served approximately 16 years, contribute to racial and social class inequity. As their mother, it was definitely a revolving door of so much pain. It's time to stop the ineffective racial bias and unjust enforcement of marijuana prohibition in the state of Maryland. The criminalization of marijuana has been unfair and too harsh for people, especially in the low-income communities where people of color lives. The war on drugs has been a failure. It has torn apart families and ruin individual lives and continues to act as a vehicle for racial injustice. And the fines that accompany these civil infraction places is a burden to them, especially it targets young people and poor, targeted by police. So I am in favor of this HB 0032, and I urge a favorable report. Thank you so much.
Thank you. Next, Christopher Stevenson for 2 minutes.
Thank you, Madam Chair and members of the Judiciary Committee. My name is Christopher Stevenson, and I'm the Senior Policy Analyst with 1199 SEIU, the largest healthcare union in the nation. And I'm here today to strongly support HB 32 because legalizing, taxing, and regulating cannabis would provide the state with the measurable benefits to the vast majority of Marylanders. For our members, our mission has been to stand up for quality healthcare, good jobs, and social justice for all. And this bill helps to ensure this goal. For many of our members who are minorities and live in majority minority neighborhoods, the arrest of minorities to small level offenses due to cannabis possessions have and continue to skyrocket. Healthcare workers themselves have even been unable to move up the career ladder due to convictions related to marijuana. To this extent, Blacks in Maryland are nearly 3 times as likely to be arrested or cited for cannabis possessions compared to whites. Moreover, punishing cannabis possessions throughout the criminal justice system also costs the state millions annually. To alleviate this problem, the legislation provides expungement opportunities and releases for past cannabis offenses, which in practice create some level of retribution for incarcerated citizens for crimes that were once deemed criminal. In tandem with expungement and release relief, the number of arrests for targeted minorities would significantly decrease for low-level cannabis offenses. This matters to our members because the arrest of minority community members not only provide a loss to families, but it consequentially disrupts entire communities, including businesses, jobs, and other socioeconomic factors. Unique legislation also allows for a better overall health impact. This bill furthers the capability for adults who suffer from medical problems to use cannabis to treat various medical ailments, such as acute and chronic pain, seizures, and more. Equally as important, the tax revenue that is made by the business produced will help our most marginalized residents in the state, including youth and minorities, due to the unique academic opportunities to fund our state's HBCUs. Given these reasons and far-reaching benefits, we urge a favorable report from this committee on HB 32. Thank you, Madam Chair.
Thank you. And next, Martin Mitchell.
Greetings, Vice Chair Atterbury and esteemed members of the Judiciary Community and the HCO members. My name is Martin Mitchell. I have the pleasure of joining High Street Strategies this legislative session, and one of our latest clients is Marijuana Policy Project. But today, I am here as a concerned citizen and a longtime cannabis advocate. I fully support the end of incarceration for the possession of marijuana, allowing home growth, and ensuring the strongest possible equity measures in undoing the trauma of the war on drugs. HB 32 will help move this effort forward in Maryland. I recognize that Maryland joined many of the states within the union by allowing medicinal use of cannabis and decriminalization for possession up to 10 grams. But Maryland has many ways we need to progress forward in terms of cannabis justice. Cannabis is no longer has the negative connotation of reefer madness and the stigma behind it, AKA propaganda. Maryland must legalize this session to join the list of over a dozen states and growing, plus Washington, D.C. that have legalized marijuana for responsible adult use for individuals 21 years of age or over. I have personally been a victim to the war on drugs. Unfortunately, it's more likely so than not for me to encounter the police as a Black boy or man living in America. These unpleasant and uncomfortable encounters I can never forget. I remember many times in particular, but I only have enough time for one. I remember seeing a municipal police officer scrape cannabis flakes off of my longtime friend's tongue. At that point, I thought through my mind, is this even legal? Funny thing, no case came from that stop, but I'm pretty sure lines were blurred and civil rights were violated. Decrim is a good step, but legalization is a necessary step towards ending cannabis incarceration. I urge you to vote favorably and pass HB 32 for Marylanders this year. Thank you.
Thank you. Next, Luke Jones. I said Miguel Jones earlier. Sorry, Luke Jones.
That's perfectly fine. Thank you. My name is Miguel Luke Jones. My family and I live in Montgomery County, Maryland. I'm a federal government employee. I've got a master's degree in public administration, and I have 30 years of dedicated public service helping to establish and administer effective local and state level regulatory programs. I'm also a citizen volunteer with the National Organization for the Reform of Marijuana Laws, commonly known as NORML, and I serve as executive director for our state chapter, Maryland NORML. We have no paid staff. I have no stake in or any investment of any kind in any cannabis business or enterprise. I've never received any fee or remuneration for consulting, lobbying, including from any cannabis business, nor has any member of my family. I represent more than 5,000 Maryland citizens who are committed to ending this demonstrably racist marijuana prohibition policy this legislative session, not next. We have a great bill. And the majority of our citizens in the state now agree with us. I am ready to respond to a range of questions from the committee regarding the views and priorities of marijuana consumers and the impact on the market and the lives of our members and our families. People who consume cannabis have unique and essential voices and perspectives regarding the longstanding cannabis prohibition policy, and we have specific set of goals that are associated with the state's approach to legalization. HB 32 satisfies all of the major concerns that have been raised by the cannabis consumer community, and this bill should be adopted as a priority in the current legislative session. Our specific policy priorities are ending marijuana-related police encounters and arrests. We think there's no real police reform without moving forward with legalization. Establishing a right of the individual to cultivate personal use amounts of cannabis at home for non-commercial purposes. 3, market access for small businesses, including cottage industry producers and other micro businesses. And 4, arrest record expungements. Finally, 5, targeted investments to repair some of the damage caused by prohibition.
Thank you, Mr. Thank you. And last on this panel is Daryl Carrington, who I didn't even recognize.
Thank you, Madam Vice Chair and members of the committee. Daryl Carrington here on behalf of Carrington and Associates. I am definitely carrying the COVID look this year. It's a pleasure to be before you all. I believe this is my first time in this session, but I'm well known to this committee. I've been working on these issues for over 8 years. I'm former executive director of the Maryland Cannabis Industry Association and founded that, and we helped to stand up the medical program. I'd like to thank Delegate Lewis and Senator Feldman and their staffs for working with me over many, many years on many of the parameters of this bill. And I think that there's been a lot of hard work that's gone into it. I like to always say that if everyone walks away from the table not getting everything that they want, you probably have a pretty good deal on the table. And I think that that's what this bill represents. People didn't get everything that they want, but I think that this is a great foundation for us to begin our legalization approach. Some things I'd just like to point out very quickly. Other states do have both medical and adult use, and they're able to do it under one framework. I think our experience shows that we need to think of being very fair and deliberate and making sure that there is minority participation. And I think the authors of this bill have done a great job to ensure that. I think that the legislature has done a good job of trying to fix the medical program to bring in more diversity. And I think that that's a work in progress. I'd like to say that I think that the fairness for the small existing independent dispensaries cannot be overstated, because those entities may find themselves out of business before this even gets started. I can also speak to this from a business perspective, addressing my good friend Delegate Grammer's question about what do we do about communities, and for my process is working with the licensees that
I'm going to have to, Mr. Carrington, I'm going to have to ask you to wrap up.
Absolutely, and Madam Vice Chair, I'll just say very quickly, what we can do is we have community benefit agreements that we make our folks sign with the communities that they are going to locate in. And we talk about things like educating our consumers and the like to ensure that they respect the community, not smoking in public, things of that nature. And we like to make ourselves available for any questions that the panel may have. And I thank you for your time.
Thank you. Committee members, I don't see any questions. Are there any questions for this panel? Delegate Williams, and I should also say we have been joined and continue to be joined by our colleagues from Health and Government Operations. So if you have any questions, please just raise your hand on the Zoom function. Thanks. Delegate Williams.
Yes, thank you, Madam Vice Chair. Just really quickly to Mr. Carrington, if you can elaborate more on the community benefit agreements that you were mentioning a few minutes ago. I just am kind of curious if kind of a little bit, find out a little bit more about that.
Thank you very much, Delegate Williams, and it's great to see you. And I miss seeing all of you in person, and I'm sure you're happy to not have me in and out of your offices all day. Nevertheless, what we did is we thought it was a good idea to look at best practices like what we did in Baltimore City when they wanted to redevelop that big property. You make sure that if you're going to come into a community, you set it up so that you have local hiring preferences from that local area. You try to procure any of your goods and services and construction and the like from the local area. And you also make sure that you work very closely with the law enforcement community and you become partners, because your success and their success are married together. And so that's a very important component that we make sure that all of our clients, all of our businesses that want to locate in any community in Maryland undertake. And I think that that's a very positive step in addressing how we make sure that the businesses are going to locate and be a benefit and not a detriment to the communities that they're in. So thank you very much for that question.
Thank you. Delegate Conaway.
Madam Vice Chair, thank you, Mr. Carrington, for coming in. Can you tell me, have you heard much from the religious communities, let's say in Baltimore City?
Thank you very much. And Delegate Conway, you know I miss coming into your office as well. I haven't had many conversations. I've spoken briefly with Reverend Hathaway about some of the social issues and the like. I've spent more of my time working with some of the pastors in Prince George's County, like Pastor Weaver, to talk about how we correct the social justice part, which, again, Delegate Lewis and Senator Feldman have done an outstanding job in addressing here. And so we've looked at those things. And plus, of course, the business opportunities for small minority businesses that have been, locked out of this industry for so very long. So as long as it's appropriate and, we incorporate things like community benefit agreements and the like, I believe that the religious community is rightly concerned about, having to try to tell our children to stay away from something. And now we're opening up these retail dispensaries in their neighborhood. So there has to be a balance. And I think that communication is really going to be the key. And that's why I always encourage our businesses anyway, to make sure that they go and build these relationships.
Okay. All right.
Thank you. Thank you very much for the question, Delegate. I'm sorry.
Okay, seeing no further questions, that concludes that panel. And we will move on to the next panel. Thank you all for coming in today. And the following individuals are favorable with amendment: Frank Boston, Warren Lemley, Ashley Bagwell, Kevin Merlat, and Joe Bryce. Okie dokie. So, Frank Boston, you are up. If you could turn on your video, please. And everyone, you will have 2 minutes.
Hello.
You ready?
Yes, I am ready.
Okay, you can begin.
Okay. Good afternoon, Madam Chair and members of the committee. I am Frank Boston III, and I am here to support with amendments House Bill 32. I represent Greenleaf LLC, also trading as greenleaf.com. I am a partner and an investor and also a lobbyist for the company. Greenleaf grows, processes, and dispenses medical cannabis throughout the state. We started in Maryland, but we now have a presence in Virginia, Pennsylvania, and Ohio. At Greenleaf, delivery to our patients is a part of our business model and fabric. It's been very successful for us, and we are able to serve our clients' needs, including social equity applicants and others. We have a fleet of 14 vehicles that serve the entire state. These vehicles cost us $22,500 a piece. Further, we install a petition and a lockbox as required by the Medical Marijuana Cannabis Commission, which costs $800 per delivery. We've been delivering since 2018, and we're basically asking for an amendment to allow us to continue to deliver. The adult use provision should not harm the medical program, and delivery helps us serve our patients and needs. And we think it'll be a convenience factor for others going forward. We have a screen share, if it's possible, that we can show you what one of our vehicles look like in the lockbox in the compartment. Is that allowed?
I don't know, Dylan, I don't know if we are equipped to do that.
We'll do it. You let me know if you can see it.
Yes, yeah, you can. You're a co-host, so you can go ahead and share that.
Okay.
You need help.
There you go. Can you see that? So that is one of the fleet of vehicles. They all look the same. They're all pretty much, a white vehicle. That is the back of the vehicle where there's a compartment, and there's the lockbox as required. And this, where's the other picture? Yeah, this is a different view. So it's part of what we do. You can take it down. It's part of what we do. It's part of our business model. And, and it makes sense. We're in the year 2021, and this will be convenient for patients going forward. And we respectfully ask that you accept our amendment and allow for delivery going forward.
Thank you. Next, Warren Lemley, you have 2 minutes.
Thank you very much. Good afternoon, Madam Chair and esteemed members of the committee. My name is Warren Lemley. I'm president of Peak Relief, an independently owned and operated medical cannabis dispensary in Rockville, actually where I grew up as well. And I serve as chairman of the Legislative Policy Committee of the Maryland Medical Dispensary Association. I strongly support legalization of cannabis for adults. Legalization will lead to thousands of jobs in Maryland, generate substantial tax revenue, shutter the black market, and finally, and most importantly, bring economic benefits to communities of color, which have been disproportionately impacted by the prohibition of cannabis. Therefore, I support House Bill 32 today with several key amendments. Ownership caps should be similar to the medical cannabis market. Individuals are allowed to have ownership interest in one grower, one processor, and 4 dispensaries per license holder, and request the inclusion of language in COMAR preventing from entities skirting the ownership caps. Lower ownership caps help protect smaller businesses from consolidation and create a more sustainable and equitable program. This in turn helps create more opportunities for entrepreneurs and more meaningful equity and ownership in the businesses that will be created. The adult use program should be a broad representation of Maryland and bring opportunities to increase the social equity and economic benefits to communities that have been disproportionately affected by the prohibition of cannabis. We also support the creation of low-tier cultivation licenses for unaffiliated dispensaries who struggle to maintain inventory, specifically flower, because many vertically integrated licensees prioritize their own dispensaries. The current medical market has faced rising wholesale costs, and many unaffiliated dispensaries are unable to source enough product for the patients they serve. Low-tier grow licenses would provide market sustainability, ensuring the same issues that exist in the medical market are not repeated in the adult use market. Low-tier cultivation licenses are important to ensure dispensaries are able to withstand product shortages and price instability. This should help bring down Maryland's high wholesale costs and result in cheaper prices, thus shuttering the black market and providing a more viable and successful adult use program in Maryland, generating more tax revenue for the state. I respectfully encourage you to support this legislation with the amendments we have identified. We appreciate the opportunity to work with Delegate Lewis and the members of the House Judiciary Committee as you continue to deliberate on this legislation. Thank you very much.
Thank you. Next, Ms. Bagwell.
Good afternoon, Madam Vice Chair and members of the House Judiciary Committee. I'm Ashley Bagwell, here this afternoon on behalf of the Maryland Medical Dispensary Association in support of House Bill 32 with amendments. I'd like to thank Delegate Lewis for introducing this bill and for including us in discussions thus far. The amendments referenced by Delegate Lewis in his introductory comments address, at least in part, a lot of the issues that we've raised in our written testimony and touch on some of the issues I wanted to raise this afternoon. First, we appreciate Delegate Lewis's consideration of a lower tax rate. We think this is incredibly important as we aim to move people from the illicit market to the legal market. My second point, Delegate Williams, you touched on when you noted that in House Bill 32, as introduced, the regulating body for the adult use program is different than the regulator for the medical program. We share a lot of the same concerns that Mr. Tilburg raised in his testimony earlier about issues that could stem from having two regulators for two programs that are so similar in nature. While the Dispensary Association takes no position on who the regulator should be, we strongly support one regulator for both of these programs. The last point I want to touch on relates to dispensary license caps. As the committee contemplates where this cap will fall, there are two things that I would urge you to keep in mind. First, that's the capacity of already existing dispensary licensees and their ability to serve more consumers. Diversity, of course, as has been discussed by this committee in previous questions, diversity is incredibly important, not only in the adult use program, but in the medical program. And I think it's worth noting that 61 out of 91 already existing dispensary licensees are women and or minority owned. The second thing I think is worth considering as you contemplate license caps for dispensaries is ways to ensure that dispensary licenses are more evenly distributed throughout the state, so as to prevent clustering in specific parts of the state and in specific geographic regions. We think that in doing so, you will help to better ensure the success of smaller independent licensees. With that, Madam Vice Chair, I'll conclude. We look forward to working with Delegate Lewis and the rest of the committee as you continue discussions on this bill and consider amendments. Thank you.
Kevin Merlat for 2 minutes. Kevin Merlat, you got to unmute yourself.
Thank you. Sorry about that. Thank you, Madam Vice Chair and esteemed members of the House Judiciary and Government Operations Committee. My name is Kevin Merlat. I'm here today as a dedicated advocate in support of HB 32 with amendments. This May, I will earn a Master of Science degree from the University of Maryland in Medical Cannabis Science and Therapeutics. It's the inaugural class. I would like to address the federal and state divide concerning cannabis and point out that similar legislation for adult use has already occurred for 1/3 of our country's population, and currently all of our neighboring states are moving towards ending the prohibition of cannabis. Maryland has earned the namesake, the Free State. My background today is a photo of a display in the House office building highlighting Maryland's role in defeating alcohol prohibition. I call on you today to stand up to prohibition once again. House Bill 32 will liberate the citizens of Maryland from cannabis prohibition and provide the groundwork for a new industry in our state. The creation of this industry will provide a much needed tax base that can be utilized to help offset some of the damages from the discriminatory practices and the war on drugs. Automatic expungement for crimes that are no longer considered a crime is 100% necessary. Regarding the social equity applicant definition, it is imperative to not discriminate for reasons of being arrested for or convicted of any offense eligible for expungement. However, I do not feel that past criminal charges should be rewarded with favorable treatment on an application review. The creation of an adult use market will allow anyone over 21 to access the healing properties of cannabis. It is imperative to keep our medical cannabis program and provide strong assurances to the Maryland registered patients to have a continued access and availability to their medication. Providing all of our citizens with the ability to acquire legal lab-tested cannabis is a matter of public health. Home cultivation is the great equalizer, allowing citizens a choice to grow in a safe manner for reasons of consistency, availability, control of cultivation, and freedom of choice. And finally, when in competition with an unregulated market, it is imperative to keep taxation low, to keep the cost of legal lab-tested cannabis reasonable. Don't let coronavirus steal this moment. We're all communicating just fine via Zoom, and I ask for a favorable review of House Bill 32. Thank you.
Thank you. Joe Bryce, you are up next.
Thank you, Madam Chair, members of the committee. My name is Joe Bryce with Manus Canning and Associates, here on behalf of the Maryland Wholesale Medical Cannabis Trade Association. We represent the majority of existing medical growers and processors. I want to thank Delegate Lewis for the approach he's taken in this bill. And Madam Chair, as you and others have said, you should not move forward unless you know that there is going to be a diverse and inclusive industry. We got off to a slow start in the medical program. And as Delegate Barron and others on HGO know, we worked with the caucus to add licenses into the medical program. And this past fall, 9 of the 11 grower and processor licenses that were issued are majority African-American owned. So it can be done. And I think Delegate Lewis's bill has several good approaches to make sure that happens. We have not advocated for adult use in the past. We do think, obviously, we have experience in the program and we have experience as regulated entities that could benefit the program. So our comments are really aimed at things like one regulatory body, which you've heard about. It's about taxation, not just what it is, but how you structure it. I think the phase in and the taxing at the point of sale to consumers is important. I think there's amendments from Delegate Lewis that would prohibit being required to have a separate inventory of medical and recreational or adult use products, which is very important for the dual licensees. And then obviously we need to discuss fees and tiers and size. And I would just ask the committee to keep in mind that all those things are really related to one another. And we need to think about them holistically. We are currently serving a rapidly growing medical market. I don't know when or if the General Assembly will pass an adult use bill this year, next year, never. And so we continue to provide to that market, which over the next 5 years could triple in size. So there are a lot of moving parts as you go to mix these two, the medical industry with the adult use industry. And I think there's things to be learned from how other states have done it well and how other states have not. So with that, Madam Chair, I'm happy to answer any questions.
Thank you. I see a question from Delegate Williams. Committee members, let me know if you have any questions. Delegate Williams.
Yes, thank you, Madam Vice Chair. My question, I think, is for Ms. Bagwell. You were mentioning some concerns with regards to the caps that's currently in the bill. I'm assuming, and I think I saw something about with the retailer caps and the cultivator caps. I don't know if you want to kind of elaborate on that, or is there a number that you think is better with it that would fit better than what's currently in the bill? I guess I'm just kind of curious about that.
Thank you for your question, Delegate Williams. I think in considering all of the proposals being considered by the General Assembly this year, and especially focusing on dispensary license caps, I think we, as we indicated in our written testimony, would lean more towards what the Senate proposal is proposing, which is 47 additional dispensary licenses. And if you look at that through the lens of how the medical program distributes the licenses, it would shake out to be one additional license per legislative district. And the reason I think that we started there is the first point that I raised and urged the committee to consider, which is the capacity of already existing dispensaries and their ability to serve more consumers. And we just thought that was a good place to start.
Okay, I don't see any other questions by the committee members, so thank you very much for coming to testify today. Committee, we do have a group of folks signed up unfavorable, and we will call them all at once. Next, Vince McAvoy, Dr. Karen Randall, Amelia Aria, Christine Miller, George Spica, Regina Ali, and that's it. That's it for the unfavorables. We'll give them a minute to come in. Amelia Aria, Christine Miller. If you're coming in, please mute yourself. Turn off the YouTube link, please. Okay, so I'm seeing Vince McAvoy is not here, so please mute yourself. We will start with Dr. Karen Randall.
Hi, can you hear me?
Yes, can you please turn on your video?
Okay, let me see if I can.
Thank you.
Hi.
Go ahead, you have 2 minutes.
Okay, my name is Karen Randall. I'm a ER physician from Southern Colorado. I know you guys are looking at proposing a bill for marijuana passage and usage there. I'm here to speak basically with regards to the harm. I'm working in the emergency department in Southern Colorado. I serve primarily an area of color, and all the kids that I see are children of color. And I need to say that looking over your bill, you certainly haven't prepared for the side effects that we're seeing here in Colorado with regards to youth usage. There is no question that youth are using more. And there's no question that when they use, they're using higher potency products, which are leading to more and more problems. My last shift, I had 3 kids who were 15 and under, all addicted to cannabis, all here because they had suicidal ideation. And the sad part is our community doesn't have enough resources to get them psychological help or inpatient care. My youngest patient was already selling herself using sexual favors for cannabis, and her cannabis career started with her dad, who thought it would be okay to start her with some because it was legal. I've had kids who come because they have accidental overdoses. I have kids who come with intentional overdoses. There's a new way for kids to get cannabis, which is using a Snapchat. And I had 2 children who both got a Snapchat interview or meet up with a person who said he was a dispensary store owner, and he sold them a single piece of candy that had 500 milligrams of THC. And for reference, the THC in cannabis in the joints of the 90s was 2 to 3 milligrams. And these 2 kids, age 12 and 14, each ate half of the candy. And so you can see there are a lot of unintentional harms. There's no question that the youth are using more. Healthy Kids survey, the most recent, indicated that kids are not only using more, but they're using stronger, and they're going to the dab, wax, and shatter when they use. So we know that this has implications for their growing brains. And there's a school officer's report that shows that kids are getting it from legal sources. So the school officers are taking away cannabis from kids who are in school. And when they ask them where they got it, over 50% said they A, got it from a parent, or they B, got it from someone else who got it legally. So it isn't a matter of trying to say that legally will keep them from getting it, because they're going to get it, and they're going to get it using the social media.
Thank you. Thank you. If you could stick around for questions, I'm sure I already see a hand up. Next, Amelia Aria. Amelia Aria, you can go ahead. You have 2 minutes.
Okay.
Are you ready?
Yes, I am ready.
Okay, go ahead.
Okay, thank you for the opportunity to testify. My name is Amelia Aria, and I'm a professor at the University of Maryland School of Public Health. My research during the past 20 years includes leading one of the largest federally funded studies on the impacts of young adult substance use, including cannabis. Today, I'd like to focus your attention on the negative impact of cannabis use on brain function and academic achievement. Unfortunately, these issues are seldom part of the legalization conversation. My testimony is based on 10 of our own published studies and studies conducted elsewhere, 54 of which I have attached. Science tells us that young adults ages 18 to 29 are the most likely to use cannabis. It places them at substantially higher risk for mental health problems, drug dependence, and blunted academic achievement, outcomes that are at odds with Maryland's mission to educate and prepare our youth to succeed. Making cannabis more available has increased youth use, erodes cognitive abilities, and increases chances that they'll disengage from school and other responsibilities. These negative impacts extend across gender, racial and ethnic groups, and individuals of all socioeconomic backgrounds, and can result in a cascade of social and economic losses across our broader society. This will only get worse as cannabis potency rises and new cannabis products are available with commercialization. We might debate a lot of things today, but I urge you to listen to science. We'd all agree that young adults in Maryland deserve a chance to thrive. No one would say, let's make it harder for our young people to achieve their potential. Let's make Maryland a leader, not a lemming, a leader in education, a leader in workplace productivity, a leader in innovation. Let's not put up barriers that compromise academic achievement, motivation, and personal and professional success. Thanks.
Thank you. Next, Christine Miller.
Yes, good afternoon. My name is Dr. Christine Miller. I'm a neuroscientist, and for over 30 years, I've researched the causes of psychosis, 10 of those years at Johns Hopkins University. Marijuana is simply the most well-replicated cause. So whatever you do to increase use, whether it's by youth or young adults or even older adults, will increase the risk for psychosis in the population of Maryland. And as you heard from Dr. Randall, there's absolutely no doubt that youth use in Colorado is going up now. It's taken a while for that effect to be seen, but there are also some academic papers showing that it was starting to be apparent. Back in 2019, there was a paper published showing that even by 2016, the rate of youth use was 25% higher in states that had legalized than in those that had not. And now you fast forward to the most recent data, which hasn't been published on yet, but that's on page 3 of my written testimony. The gap has widened to 55%. So not only, as Dr. Randall pointed out, are they using more, they're also using more potent products, which have more serious mental health outcomes. Marijuana use leads to psychosis in about 1 out of 20 daily users, an outcome more likely than from any other recreational drug, and I give you references for that. Drug-induced mental disorders are associated with becoming homeless, and this committee has heard from me before on that, but if you look at page 10 of my written testimony, just focusing on marijuana, the rate of homelessness in states that have legalized is 2.5 times the rate of homelessness in other states. Marijuana is associated with an increased risk for suicide, and you heard from Dr. Randall about that. It has a more unpredictable risk profile than the 2 legal recreational drugs, alcohol and nicotine in the form of cigarettes. And that if you would administer actually purified THC to subjects in the clinic, these studies have been done in Europe, 40% of those who have no family history of psychosis will develop psychotic symptoms. So that shows you that you cannot predict in advance who will be safe from this drug. To conclude, I'll put on my environmentalist hat. I just want to say I don't know why cannabis is given a pass for its carbon footprint. It is huge. In indoor grows, which is how it is predominantly grown in Maryland, the carbon footprint is larger than any other industrial product, and it is much larger than any plant or animal grown for food.
Thank you, Dr. Miller. Thank you. Next, George Spica. George Spica, are you in?
Okay, see me?
Yes, there you go. Go ahead, sir.
Great, thank you. I'd like to thank Delegate Lewis for mentioning the health aspects of marijuana. I'm 74 years old, and for the last 50 years or so, I've struggled with mental illness because in my early 20s, I became addicted to marijuana. And then after my 25th birthday, I suffered a psychotic breakdown. I detail that in my written testimony, kind of what I went through. And the first time I got relief was around 2000 when I started modern antidepressants. I mean, the health issues are still there, but it's not like I'm buried in it. And I guess about 6 years ago, when marijuana started to be legalized, I started doing my own investigations, trying to find out what happened to me. And I uncovered a wealth of research. I'm not the only one that's happened to. U.S. Surgeon General and the National Institutes of Health and the Center for Disease Control and Prevention, they all talk about this. What happens to your minds, especially adolescents. And the more powerful the THC, and when I was young, it was like 3%. Now it's said to be around 15%. The powerful the THC, the more likelihood for addiction. And Jerome Adams, our Surgeon General, talks about that specifically. And he tells, adolescents and pregnant women should stay away from marijuana. And I've seen this other testimony where moms who smoke marijuana, they give birth to kids that have defects to the prefrontal cortex, which is the area of the brain that's the major area for decision making and all that kind of stuff. And this is the stuff that Marijuana Policy Project doesn't want you to know about. That's why I recommend reading my written testimony, because I cover a lot of data.
Thank you, Mr. Speaker. There's questions. So, and last to testify on, two more individuals. Miss Regina Ali.
Good evening. Can you hear me, Madam Chair?
Yes, go ahead.
Yes. Good evening. Thank you. Good evening, Madam Vice Chair and committee members. My name is Regina Ali, and I am the Public and Government Affairs Manager for AAA Mid-Atlantic here in Maryland. While we at AAA recognize the social complexities of House Bill 32 and the public policy impacts of the legislation, AAA opposes the legalization of recreational cannabis due to the inherent traffic safety risk. According to research by the AAA Foundation for Traffic Safety, fatal crashes involving drivers who recently used cannabis doubled in Washington state after legalization. And crash rates and insurance claims also increased not only in Colorado, but in Nevada and Oregon following legalization as well, according to the Insurance Institute for Highway Safety. Colorado saw a 153% increase in fatalities with drivers who were positive for cannabinoid only or a combination of cannabinoid in combination with other drugs and/or alcohol after legalization. Another concern for AAA is the challenge that police officers face in determining impairment at the roadside. Currently, no testing procedures exist to reliably predict driver impairment due to consumption of cannabis. Unlike with alcohol, there is no breathalyzer test that can be given. As a result, law enforcement must undergo costly, time-consuming additional training to be certified as DREs or drug recognition experts. Cannabis can affect people differently, making it challenging to develop consistent and fair guidelines, and there is insufficient scientific data to provide motorists with guidance on the use of the drug in a way that does not impact their ability to drive safely. While AAA remains opposed to legalization, we have provided several recommendations to be considered for inclusion in any legislation to legalize cannabis in the interest of traffic safety and fairness to motorists, which you have in our written testimony before you. As an advocate for the safety of motorists and all roadway users, AAA believes it's dangerous to legalize cannabis before we are prepared to safely manage the potential roadway safety consequences and provide law enforcement officers with all the training and resources they need to address this critical traffic safety issue.
Ms. Ali?
Yes, I just wanted to say thank you.
Okay.
I'm sorry. We thank Delegate Lewis for listening to our concerns in advance of the hearing, and we certainly thank the committee for your consideration. And due to the traffic safety implications, we urge an unfavorable report for House Bill 32. Thank you so much.
Thank you. And the last person to testify on this panel is Vince McAvoy. And you have 2 minutes, Mr. McAvoy.
Thank you so much, committee. I want to highlight what Delegate Lewis said. He said that he wasn't saying cannabis is useful or good. He also said there was concern about arrests and particular demographics. Okay. If you're talking about Baltimore City, I want to say mission accomplished. We do not arrest for cannabis, maybe cannabis and drugs, maybe cannabis and something else, but not cannabis. And we don't arrest even for cannabis and driving. I want to tell you, bouncing off what the previous testifier just said, you can't go 1 block without encountering a car where someone is driving with this. It is epidemic. And you can tell by the number of cars that are T-boned in the city. It's gotten off the hook. Delegate Lewis's bill will have no way of controlling for this, as Delegate Brammer was talking about. You just simply cannot control it. So children will be exposed to this, will be eating the candies. And you already have parents advocating through their use that children should use drugs. As Colorado and Arizona move forward with this failure, the websites giving the data that's being spoken of by these other people, it's being disappeared, it's censored, it's being censored from the web. And so we see the same thing with Delegate Valentino Smith bringing a bill to look at testing for cannabis. We're actually having the judiciary not giving, I think, the full weight to what Delegate Valentino Smith is bringing to you. She and her bills were suppressed. When we're looking at the gambling or sin taxes, these never pay off. We saw this with gambling in the schools. We will see the same for this. Many promises, nothing delivered. In closing, I want to say that in 10 years, I've never advocated against this. But this testimony isn't just for this bill. This is for all of this. We see what this is now, and that is not what we saw in the 70s. The committee needs to reverse course. It is affecting our children. We are not going to have children going through and prospering like they once did if we have a culture that embraces this. So thank you so much for your time.
Thank you. And we do have several questions from the committee members. First, Delegate Lopez, and then Fisher, and then McComas. Delegate Lopez.
Thank you, Madam Chair. My question is for Dr. Randall. In your testimony, you talked about marijuana overdoses, and this is the first time I've heard reactions characterized in such a way. Typically, when you think of an overdose of another illicit substance, it's where you've consumed such a significant amount that your body cannot process it, and so you have mental and somatic reactions to it. It sounds like a marijuana overdose is just simply a bad reaction to the typical amount that could be consumed, and these reactions don't have the same degree of fatality as of other illicit substances. Can you just untangle that a little bit more?
Sure, I'd be happy to. First of all, I'd have to ask, what is the typical amount? Because no one really knows, but what we do know is what the community has done right now is that there is super high potency. And there's also these concentrates that kids are having. And yes, they have physiologic side effects. I've seen acute psychosis. I've seen acute depression. I've seen altered mental status. I've seen people who come in comatose. So yes, they all have side effects. This is no different than any other psychoactive drug.
Thank you.
Okay, thank you. Delegate Fisher.
Thank you, Madam Chair, and you're running the committee so well this evening. I have two questions for one for separate individual on of the panel. My one question is, first one is for Ms. Ali. You know, I'm a criminal defense attorney, and the reality is people are driving high now, and we're prosecuting them, and they're going to court consistently. So I just wanted your opinion on the fact that we're already having to deal with it as an issue, and our case law is there to prosecute and have justice. So that's my question to you. The other questions for Miss Aria is about, would you, in your opinion, do you think that marijuana is do you agree that cannabis is a less harmful substance than alcohol? Because a lot of the things that I've heard in this testimony around the health effects, I see those same things with alcohol, and you know, the decisions and different trauma that people go through, you know, to act like one thing is a contributing factor, I think is a lot to say when it comes to people's health and their experiences. So I really want to directly know if do you agree that cannabis is less harmful than alcohol? So those are my questions. Thanks, Madam Chair.
I'll go first if you like. So your question, I'm sorry, Delegate, was because people are already driving high now and it's not legal. I didn't quite catch your question.
I'm just saying that, you know, from the testimony that I heard, and I could have misinterpreted, it was saying as if we legalize it, you know, people abusing it and driving vehicles are going to become a problem. And I'm saying it's already a problem we're dealing with every day in courts in Maryland around the state. So I just don't, just because there's not a machine that can go in there and click how much weed you have for time, you can still prosecute, you know, a DUI per se. And I've done it myself and gotten convictions. So I'm just saying that I don't see a problem when our court system and our laws on the books are already there to handle when you're driving incapacitated.
Well, unfortunately, what we have seen in other states across the country, Delegate, respectfully, is that when marijuana is legalized, that you actually see an increase in usage. So many people who may have not actually used it now are using it because it is legal. And what the concern is mainly for AAA is that there really isn't any guidance for motorists. So with alcohol, we know that 0.08, you're considered illegally drinking and driving. No such levels exist as it relates to driving under the influence of cannabis, and that's in part a large part of our concern.
Thank you for the question, Delegate Fisher. It's a great question. And my short answer is different drugs, different harms. We get asked this question a lot, and we've done research on it. And what we found is that the pattern of use of cannabis is very different than the pattern of use of alcohol. Among young adults, most people use cannabis at different times during the day, before school, if they're a daily user, at night, alone. And typically alcohol is used in social settings where there's other people around. So what starts to happen with educational achievement is that cannabis is actually more impactful on cognitive function and educational achievement, according to the science, than alcohol, because of that pattern of use. Of course, when you get dependent upon alcohol, or you get dependent on cannabis, probably they become more equal. But among young adults and among adolescents, the educational impact appears to be greater for cannabis. It slowly erodes your ability to function and to be motivated and to engage in school. That's one of the things. Then there was a comment about public intoxication, and that is very different for cannabis and alcohol. Public intoxication is much more noticeable for a person who is drunk. But a person could be using cannabis and not functioning or not able to really engage, like let's say taking care of children. And there's a whole movement out there, the marijuana mommy movement, where mothers are bored taking care of their kids, and they write about how they can get high and take care of their children because they can sort of disengage from their parental responsibilities. That is very different than being drunk around your children. different drugs, different harms. So the pattern of use is different. The educational impacts are more severe with cannabis, and public intoxication can be less obvious in with cannabis. Thank you for your question.
Thanks. And I guess my follow-up would be, you know, alcohol can be extremely dangerous. I've seen people lose
I
their.
agree.
I'm in court with it every single day. I mean, but it's not something that we prohibit. And I just think like a systematic system of honestly oppression and racism, should that, you know, should the concerns of certain people's actions and their personal choices outweigh the fact that, you know, should we prohibit something? And I think alcohol can be extremely dangerous. It takes people's lives. It causes car accidents. It does a lot of stuff. Do you think that alcohol should be prohibited then based on your rationale?
I think limiting access and availability is the best public health approach to solving this problem. And I don't think that legalization is the answer to prohibition. I think that we have to
we should limit access to alcohol in the state of Maryland.
I think that we should card bars that serve to underage consumers. I think we have very, very strict regulations on potency. I don't think it's the Wild West with regard to what percentage of alcohol is in a certain beer or liquor. I don't think we have that kind of regulation on the types of products that are available for cannabis.
Thank you.
Delegate McComas.
Thank you, Madam Chair. I appreciate. This is probably for Dr. Randall, and one of the other panelists may want to comment. It's my understanding that the frontal lobe and your judgment is not fully formed until you're age 25. Is that correct, doctor?
That's correct. And Christine Miller's on the panel. She's an expert in neurodevelopment and neuropsychology, but yes, that's correct. And that's part of the concern we have for youth using, is that they're actually not, they're harming themselves. And so probably would even say up to 25 years of age on average.
So if basically, if we legalize marijuana, that says to the public, it's okay because it's legal. So usually that filters down to the kids and, you know, saying,
yes.
So they're going to, you know,
without a doubt,
Right.
Our kids are getting pot from their parents who feel it's harmless because it's legal. There's no question.
So is it fair to say that we could be really messing up some young people's brains?
Oh, absolutely. And this is going to happen. I live and work in a community of color, and this is going to happen in communities of color. I live in Southern Colorado, and we have a population of 160,000. We have 50 retail dispensary stores or thereabouts. I know that in the affluent communities of Vail or Aspen, those aren't there. Those aren't there. They're here because this is an economically poor community, and it is a community of color. And all the kids I see are kids of color, and I don't have resources to get them. That's the issue, is once they get started, there's no resources to get them back off the drugs, back on track, and back on a par with their peers so that they can actually become successful. Because the second the door opens for cannabis use, they decrease school, they decrease activities, they become depressed, they become suicidal. And honestly, the kids I mentioned previously, one girl sat in the ER for 3 days waiting for a psychiatric bed. And I know that people gave testimony on another bill about how much psychiatric resources Maryland lacks. And it's the same in Colorado. And you guys probably don't have the infrastructure to provide an increasing amount of psychological and addiction counseling for minors, people who are in their teens. We have kids who are using in elementary school. And why? Because it's legal.
Well, my other question, and maybe Mr. Spica can comment, but there was this discussion of that if you use marijuana, you can have psychotic episodes. Could you kind of explain what a psychotic episode is, and whether if you do have a psychotic episode, can you easily recover? Is it just like a hangover, or is there something more to it?
You're on mute, sir. You're still on mute.
Here we go. It's like I said, I've been struggling with mental illness for close to 50 years. And I had the daily thoughts of suicide also. And that was until about 2000 when I started those antidepressants. What it physically was like, it was like I was being crushed between a wall of anxiety and a wall of depression. And in my mind, and I couldn't get rid of this, it kind of faded after about 10 years. It was like there were these writhing, flaming tentacles. And, you know, when I closed my eyes, you know, it was still there. I was lucky to get 4 hours of sleep a night. The two main reasons I survived was one, my willpower. I mentioned in my testimony that I had this mantra that I would say to myself, hang on, things will get better. And the other reason was that my wife was very loving and supportive. You know, that helped too. But yeah, it doesn't go away, you know. It could be a lifelong affliction like me.
Thank you. And I don't see any further. Oh, Delegate Conaway will be the last question for this panel. Delegate.
Thank you, Vice Chair. To Ms. Miller, could you describe what your perspective is on the psychosis? And is that something that once it starts to happen, does it happen frequently, or if a person discontinues their usage, do they continue to have it, or how's that work?
Yeah, that's a really good question. I would say with marijuana-induced psychosis, the first symptom is almost invariably paranoia. So, you know, a teenager afraid that, you know, their friends are talking behind their back at school, you know, they hate them, they want to kill them, that kind of thing. And what happens is if they progress to what they continue using, they can progress to a full psychotic break, which means a cluster of psychotic symptoms happening at once. You know, not only are they paranoid, they think that, you know, they're Jesus Christ, and so they have delusions. And not only that, but they can actually have outright hallucinations. They can hear voices. And if that happens at once, that's when they generally present to an emergency room like Dr. Randall's place of work, and they have a full psychotic break. So that progression is variable. With we know some teens that it's happened, you know, immediately with their first dose of potent pot. And one very sad case in Colorado where the kid didn't recover after a few weeks and committed suicide because he just couldn't get his mind back. But with others, it can take a while. And so, you know, even after 3 years of use, they have not fully realized what is eventually going to be the damage to their brain. After the psychotic break happens, then what can happen is if they persist using, the data are in for many different types of recreational drugs. In Finland and in Denmark, they conducted a study of over 24,000 people who had one type of drug-induced psychosis or another. And it was cannabis that 8 to 10 years out, inevitably 50% were still psychotic.
Thank you very much. Thank you so very much.
Sorry.
Okay, thank you very much to this panel, and we will move on to our last panel. Aubrey Adams, Christopher Hammond, and Eric Spencer. And they have all signed up as information, but I think they might be unfavorable. We'll see. And then committee, after this last panel, we have a very quick vote, Judiciary, to do. Okay, Ms. Adams, you can go ahead and you have unmute yourself and you have 2 minutes. Go ahead.
Okay, 1 second here. Sorry, I'm a little nervous. Thank you for allowing me to have my comments. Can you hear me? Okay. My name is Aubrey Adams. I'm a former Colorado mom. Sorry. I have firsthand experience of how legal marijuana affects a family and a community. I moved out of Colorado in 2018 because of the promotional policy of marijuana, lack of treatment for addiction, and often being exposed to marijuana smoke and smell almost everywhere we went, including schools, parks, stores, and movie theaters. I strongly advise you to oppose HB 0032. It allows a predatory addiction for profit industry to target and market our kids. My son started using marijuana edibles in the 8th grade soon after legalization, and then he began self-harming. I didn't know he was using marijuana because the industry makes products in deceptive forms to disguise use. By February 2015, my son was irrational. He was paranoid and repeating things that did not make sense, which I now know is termed as a psychotic break. One night, he was so violent towards his younger son that his brother ran barefoot through the snow to get away from him. He attempted suicide and was hospitalized. When he was discharged, he was still suicidal. And I took him back to the ER where I was told it's just marijuana. And we were sent home. Within a few days, my son was hospitalized again in a different town because there were no available beds in our town. He told me he was using dabs and he knew they were making him feel crazy and he was trying to quit. He described dabs as strong marijuana and he called them crack weed. Dabs are highly concentrated THC products, mass produced and to appeal to teens despite the regulations. I volunteered my family for crisis intervention with the Department of Social Services because I couldn't find treatment for marijuana abuse. My son had developed the pediatric disease of addiction. And by the next year, not only was he using marijuana, but he was using meth and heroin. Marijuana kills. It is a gateway to more drugs and pharmaceutical drugs. My son allows me to tell a story because he wants the nation to know that marijuana is deadly, harmful, and can change you forever with delusional thinking, hallucinations, and an increased risk of suicide, depression, and addiction. Please oppose this bill. The science proves marijuana is a hard, dangerous drug. For the marijuana industry to be profitable, they need more and future users. Those users are the youth of Maryland. We need future leaders, not future users. If you will allow me to continue to comment, I want you to know that it is extremely painful to hear the misinformation from the people that support these bills. And that's why
you have gone over and I appreciate you telling your story. Perhaps there'll be a question for you. Thank you. Next, Christopher Hammond.
Hello, Chair, members of the House Judiciary Committee. My name is Christopher Hammond. I'm an MD, PhD, a physician scientist with training in child and adolescent psychiatry and addiction medicine. I've worked for over 10 years providing clinical and research services to children and families impacted by substance use and mental health disorders. And I currently direct clinical research and educational programs at Johns Hopkins focused on this space in particular. I'm here today to provide unbiased scientific background and to answer any questions that you have about the risks related to cannabis use and effects of cannabis legislation on health outcomes in young people and people with mental health problems. I feel strongly that House Bill 32 and any future cannabis legislation should be evidence-informed, and that our state legislators should rely on sound empirical data to guide their legislative decision-making. Relatedly, current scientific evidence shows that over the past 2 decades, in context of expanding state-level marijuana legislation, that societal perceptions about cannabis and cannabis use patterns have shifted for American adults and adolescents. Focusing on young people, cannabis remains the most commonly used drug by US youth and is the main drug that adolescents in America present for substance use treatment. There's growing scientific evidence from a number of different lines of inquiry showing that adolescent onset cannabis use, even after controlling for confounding factors such as alcohol use, premorbid IQ, socioeconomic status, is associated with immediate and possibly long-term impairments in cognition, worse academic outcomes and vocational outcomes in adulthood,
Mr. Hammond, I'm going to have to ask you to wrap up your testimony, please.
and an increased prevalence of psychotic, mood, and addictive disorders and suicidal thoughts and behaviors. And the odds of these are worse with earlier onset use and higher potency use. Marijuana legislation does impact youth perception and behavior, and I just would be happy to provide any additional information and guidance as it relates to this bill, and to answer any questions related to cannabis.
Thank you. And I see the chair is back. Mr. Chair, we have one more to testify.
Go ahead and call that person because you've got the list.
Thank you. Mr. Spencer, you may go ahead. You have 2 minutes.
Mr. Spencer, go ahead for 2 minutes.
Thank you. Can everybody hear me?
Yes.
Chairman Clippinger, Vice Chair Atterbury, and members of the committee. My name is Eric Spencer, and I'm a first-time nonviolent felony offender, having served over 13 years in federal prison for marijuana and other drugs. And while I support the idea of legalization of recreational cannabis in Maryland, House Bill 032 needs to be revamped in its current form. True equity is wanting. As this committee is fully aware, Maryland has had great difficulty in achieving equity in its medical marijuana program and seems to be going down the road again in the creation of its recreational program. First, HB 32 seems to have adopted the model of Illinois per se by crafting language which ensures that current cannabis companies get to pay a fee to sell recreational marijuana first. If this transpires, any thoughts of a robust social equity program will be just that, a thought. Not one social equity participant has been granted a retail license in Illinois, and they have been accepting applications for over a year. Maryland must be intentional by appropriating adequate funding of 15 to 20 million to a cannabis loan fund outside of any funds given by the current cannabis companies already operating medical businesses, cannabis businesses, in order for a sound social equity program. Current medical marijuana operators should have to wait for at least 6 months after the law takes effect to allow social equity participants to apply first and get approved for recreational licenses of all types, especially retailers' licenses. Social equity participants should not be forced to compete with any qualified applicant for a retailer's license. Any qualified applicant entails professionals with decades of experience in various aspects of running a business. Maryland's legislature must keep in mind the reasoning behind social equity and its application to its recreational cannabis legislation. Virginia's legislatures were intentional when they formulated their industry-leading social equity program. In Virginia, big boy cannabis companies will not be in line first to sell recreational marijuana. Social equity programs will get the opportunity to sign up first when the law takes effect and the infrastructure is set up. Virginia also budgeted $15 million for a cannabis loan fund, and which will grow. The proposed Virginia legislature calls for 66% ownership by social equity participants and not 51%.
Mr. Spencer, if you would wrap up your comments, please.
I'll leave this committee with the wise words of Virginia Delegate Paul E. Krizak in an exchange with a policy representative for multi-state cannabis operator Columbia Care during the crafting of Virginia's industry-leading legislation. We will not be a rubber stamp to the cannabis industry. I encourage Maryland to do the same, especially since their medical marijuana program was created in a shameful and biased manner at best. Thank you.
Thank you very much. Are there questions for this final panel? Seeing none. Thank you all very much for your testimony. That concludes the testimony for House Bill 32. We thank you all very much for spending time with us today. I appreciate it. Committee, we also thank members of HGO who were with us. I see you, Delegate Riley. Thank you for joining us today. And Delegate Barron is not there, but that's okay. Members of the committee, we have to do a reassignment. 7 days from the after the bill is dropped or after a bill is assigned, in order for us to reassign a bill, it has to be voted out to the other committee by this committee. The bill in question is House Bill 1268, Delegate Henson's bill, and it is truly more appropriate to be in the Appropriations Committee. It has to do with more spending than about the actual legal education or the bar. And so to that end, if I could have a motion, please.
Move to reassign that bill out of here.
Thank you very much.
Second.
Moved and seconded. All in favor will say aye.
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 Is there
Aye.
anyone opposed? Seeing no one opposed, the ayes have it. All right. So we will take care of that. All right. We will be back tomorrow with over 160 witnesses for bills related to landlord-tenant matters and evictions. So we are going to have a very full day tomorrow. I would expect we're going to start
160 witnesses.
I would expect that we will almost certainly break it.
You know, I'm
Delegate Davis, you're not on. There you go. I think we'll set a break at 5:30 tomorrow, but we'll play it by ear. If it looks like we might be done by 6:30, I won't call a break at 5:30. But if, as I'm kind of thinking, we probably will be in that place, we will break for dinner at 5:30 and come back at 6:30. Delegate Conaway.
Thank you, Mr. Chairman. I have a bill that's been assigned to Environment and Transportation, but it says landlord and tenant lease agreements. It's HB 0960. So I didn't know, should I bring that to your attention? Just let it ride? What?
No, I think that is properly in front of Environment and Transportation. These bills have to do with, we deal with the fees that people have to file for evictions. Okay. And we have bills related to shielding and actually filing the evictions. It's sort of that technical process, not what is part of landlord-tenant agreements.
Thank you, Mr. Chairman.
Yeah, that's up there. All right. With that, we will see you again tomorrow. Thank you all, committee, very much for your